For those of you who read my book, Outrage, The 5 Reasons O.J. Simpson Got Away with Murder, or saw the analysis portion of this program, you're aware of the reasons I believe a double murderer went free. Chief among them was the incredible, mind-boggling incompetence of the prosecution. They failed to introduce a great amount of incriminating evidence. They inadequately explained evidence they did present. They were poorly prepared throughout the trial. They lacked fire and passion in their addresses to the jury. And as if all that weren't enough, in their final summation, they virtually conceded, by default, the central core of the defense's case that O.J. Simpson had been framed by the LAPD. In my earlier analysis, I pointed out in many areas what was or was not done, what should have been done, and in some instances, how I might have addressed the jury on certain issues. In a moment, I'll tie much of that together and present to you as one of the jurors some of the highlights of a final summation I might have delivered had I been the prosecuting attorney. First of all, though, let me define some terms which the media frequently confuses. The opening statement is that which is given by both the prosecution and the defense at the beginning of the trial, before the presentation of the evidence. This is not to be confused with the opening argument, which occurs at the end of the evidence. The prosecution gives the first argument to the jury, their opening argument, which is followed by the defense's one and only argument. Then the prosecution, because they have the burden of proof, gets one last chance to address the jury in a closing argument or rebuttal to the defense's argument. All these arguments are generally referred to as final summation. The conventional wisdom is that a summation should be succinct, focusing only on the main points in the case. Not only can't a lawyer keep a jury's attention for more than an hour or so, it is said, but discussing the smaller points only clutters and dilutes the thrust of the main arguments. I may be wrong, but my personal opinion is that this couldn't possibly be a more serious mistake, in many cases perhaps a fatal one. Juries, unaccountably, often base their verdict on, or are heavily influenced by, the most tangential, seemingly insignificant points. I also don't agree that it is difficult to hold a jury's attention for more than an hour or so. In fact, it's not difficult to keep their attention for 1, 2, or even 3 days. If the lawyer can deliver a powerful, exciting summation that is sprinkled with example, metaphor, and humor, and particularly when he makes it obvious to them that he has a lot of important observations to make about the case, and they can only fulfill the oath they took to reach a proper verdict if they listen to him closely. That is, if he convinces them that they need him. Since I want the jury to be able to refer to my arguments back in the jury room, I always urge them to take notes during my summation, citing an old Chinese proverb I've always subscribed to, that the palest ink is better than the best memory. The producer of this program asked me to deliver, on camera, what my summation would have been in the Simpson trial if I had been the prosecutor. The same thing was asked of me by the editor of my book, Outrage, that I write out in the book what my summation would have been. I told them both, as I now tell you, the viewer, that this is not realistic. If I had been the prosecutor in this case, I would have easily put 300 to 400 hours into the preparation of my summation, and it would probably have taken 2.5 to 3 court days to deliver. For instance, my opening argument would have not only included a recitation of every piece of incriminating evidence against the defendant, from top to bottom, but an analysis of all the testimony and evidence in the case, including that from the defense. Obviously, because of time constraints, that will not be done here. There will only be selective references to testimony and evidence in my opening and closing arguments. Also missing will be sections of my summation, such as one in my opening argument, where I always preempt the defense by briefly summarizing for the jury what I just about know the defense attorneys will argue to them. In a real trial, I also, of course, would have made use of some of the many exhibits introduced as evidence, and would have utilized the easel and the blackboard. I should add that a luxury I do not have here, which I would have had if I had tried the case, are the months and months to write and prepare the summation, as well as go over it, to the point where I wouldn't have to rely on my notes as much. What I would like to do now is present a shortened opening and closing argument to you, where you are a member of the Simpson jury. My summation will touch on those areas most critical to the case for the prosecution, and, not surprisingly, the same areas most neglected by the actual prosecutors in the trial. For those of you who might wonder why you won't be hearing from the defense, let me remind you that this is not a situation similar to where I faced off with Jerry Spence in front of a jury in London for the 21-hour television docutrial, On Trial, Lee Harvey Oswald. Because of Oswald's death, there was no trial, and we tried to fulfill a what-if situation with the actual witnesses in the case, a real judge and jury, no script or actors, and a defense attorney, Spence, representing Oswald. Here, however, there was a trial, and we have already heard from the defense. We know what Simpson's defense attorneys had to say. We know what their arguments were. The summation I'm about to make includes arguments that I think should have been made by the prosecution to counter these defense arguments. The summation I'll be making will include, in some cases, references to evidence not offered by the prosecution during the trial, which I would have offered, such as Simpson's tape-recorded interview with Detectives Lang and Van Adder, the suicide note, the slow-speed chase and evidence seized thereafter, etc. It will also include references to witnesses I would have called whom the prosecutors in the Simpson trial elected not to call, such as Faye Resnick, as well as some testimony the prosecutors did not elicit from witnesses whom they did call. I will not be referring to evidence that was not available to the prosecutors at the time of the criminal trial, such as the highly incriminating photos of Simpson wearing the precise type of Bruno Magli shoes we know the killer wore and which Simpson said he had never owned or worn. Those photos surfaced after the criminal trial and were used to very good advantage by lead plaintiff's lawyer Daniel Petrocelli in the civil trial. The argument you're about to hear then will be a proposed argument in the criminal trial of O.J. Simpson, a trial which varied significantly from the subsequent civil trial. As we've discussed, the criminal trial had a predominantly black jury, and the racial composition of the jury I'll now be arguing in front of will be the same. The jury in the civil trial, on the other hand, was predominantly white, with only one black on it. The burden of proof the prosecutors had to meet in the criminal trial was beyond a reasonable doubt, much higher than the burden of proof the plaintiffs had to meet in the civil trial, which was merely a preponderance of the evidence. Also, Judge Fujisaki, the civil judge, virtually eliminated the main defense theory at the criminal trial, that of a police frame-up, by not allowing the defense to play the race card. Mark Furman, for instance, didn't even testify at the civil trial. The summation you're about to hear will be very heavy on anti-conspiracy arguments, since the defense built almost all of its case around the police frame-up theory. In listening to it, some of you may at some point say, enough. But you must realize that the jury in the criminal trial of O.J. Simpson actually bought this defense argument. Also, my state of mind would have been the realization that if just one of the 12 jurors before me bought the police conspiracy argument, it's a hung jury, and the prosecution would have had to try the case all over again. And as to that potential one or more jurors, I could never know which one of my anti-conspiracy arguments might resonate with them. 8 of them may not have, but the 9th might have. The emphasis in all my arguments to the jury, anti-conspiracy as well as others, will be on logic. Logic is something that only a bad person has no interest in hearing. And my mindset facing this jury would have been that I had no reason to believe I was talking to 12 bad human beings. My objective throughout the summation would be to convince the jury it had no choice but to return with a verdict of guilty. After making a few introductory remarks to the jury at the start of my opening argument, I'd probably make the following rhetorical statement right at the beginning to psychologically jar the jury back to reality. I'd like to make an observation, ladies and gentlemen, about a matter that could be on your minds, either consciously or subconsciously. You've been sitting here now in this courtroom for over 9 months, listening to a great number of issues being vigorously contested by each side, the prosecution and the defense. You've heard close to 200 witnesses give thousands of pages of testimony. Because of this, it could be natural for you, as lay people, to say to yourself, you know, there must be a real issue as to guilt here, because if there isn't, why have we been here in this courtroom for over 9 months? Why have we been here for over 9 months if there's no real issue as to guilt? Well, ladies and gentlemen of the jury, we've been here for over 9 months, not because there's any real issue as to guilt. Based on the evidence that came from this witness stand, Mr. Simpson's guilt could not possibly be any clearer. I mean, when your blood is found at the murder scene, your fresh blood at that, that's really the end of the ball game. There's nothing more to say. We've been here for over 9 months, simply because Mr. Simpson pled not guilty and came up with a desperate defense. And in America, no matter how guilty you are, I don't care if there's 100 eyewitnesses that saw you commit the crime, our system of justice, and I wouldn't change this for anything, I'm not quarreling with this, our system of justice allows you to plead not guilty, offer a defense, and have a trial. And that's the only reason why we've been here in this courtroom for over 9 months. There is no other reason. And what has that defense of Mr. Simpson been in this case by these defense attorneys? I think you and I have seen that there hasn't been any depth, no depth, to which these defense attorneys haven't been willing to sink to enable this man to walk out of this courtroom so he can start playing golf every day. For instance, fraudulently injecting race into this case when there's no racial issue involved in this case. This is simply a case of a man who happened to be black, murdering his former wife, and a young man who happened to be in her presence at the wrong time. In a related vein, and this is the heart of their case, these defense attorneys, without any evidence at all to support this outrageous allegation, have falsely accused innocent police officers of framing this man of 2 murders. Black and white police officers, particularly during the early years of their careers, risk their lives almost every day, not even knowing when they give a ticket to a speeding motorist whether he's going to be some zany or some escaping criminal that's going to blow their brains out. They're sued, they're called pigs, and then after detectives like Lang and Van Adder have put in 25 long and hard, gritty years serving the public, and they're about to retire and spend a couple years with their families, enjoy a couple years, criminal defense lawyers like Johnny Cochran, Barry Scheck, and F. Lee Bailey come along and in front of millions of people falsely accuse them of the most despicable act imaginable, framing an innocent man for 2 murders. That's really nice, isn't it? The question I have for these defense attorneys, have they no sense of decency? Have they no shame? What else has the defense done in this case? Well, we've all seen their technique, their modus operandi, if you will, of treating every question that they asked as being the equivalent of proof, splitting hairs with all the evidence, and then proceeding to split the split hairs, focusing in on one penny ante, mistake, discrepancy, or inconsistency, and then trying to either blow it completely out of proportion or tell you folks that it's evidence of a conspiracy to frame this man. But if you put virtually any criminal case under a high-powered microscope, you're going to find a couple discrepancies here and there. Inconsistencies, slip-ups, unanswered questions, incompetence. However, when you look at all these things in the context of the entire case, they don't add up to a hill of beans. These things happen because of the nature of life. You folks know from your own personal experiences in life. Things don't proceed with mathematical precision and an apple pie order. And the law takes cognizance of that fact. That's why the prosecution only has the burden of proving this man's guilt beyond a reasonable doubt, not beyond all doubt, which, of course, in this case, we actually have done. I mean, people are human. They make mistakes. That's why they put erasures on pencils. In this trial right here, we've seen one innocent mistake after another. Just a few examples. My co-prosecutor, Rockney Harmon, very competent guy, asking one of our witnesses, his name is Gary Sims, he says, question, Mr. Matheson, are you a part of some conspiracy to frame the defendant in this case? Answer, my name is Sims, not Matheson, and no, I'm not. Johnny Cochran wasn't any better with names during this case. In his opening statement, he referred to Ronald Fishman, a friend of Mr. Simpson's, twice in his opening statement as Ronald Goldman. Also, Cochran, in his opening statement, told you that Dr. Kerry Mullis, who he said was going to be a defense witness, but he never ended up calling him to the stand, he said he had won the Nobel Peace Prize. But Dr. Mullis had never won the Nobel Peace Prize. F. Lee Bailey and questioning LAPD Sergeant David Rossi, referring to the California Health and Safety Code as the California Penal Code. Thano Paradas, we know, removed the blood from Mr. Simpson's left arm the day after the murders, June 13th, 1994. Then he takes that vial of blood and he puts it in an envelope whose date on its label says May the 10th, 1994, more than a month earlier. This is life, and we all know this. I was told that just last week there was an article in the paper talking about the space flights from Cape Canaveral, Florida, the whole history of those space flights. And among the many gaffes and blunders that they mentioned, including those that caused the Challenger disaster, of course, in 1986, caused the result in the death of 6 American astronauts, on the Apollo 8 flight that circumnavigated the moon, when Colonel Frank Borman, the commander of that flight, was sending transmissions back to Cape Canaveral, he referred to the Apollo 8 flight as the Gemini 8 flight, a flight he had participated in 3 years earlier. Now just consider the monumental preparation that Colonel Borman must have put into that flight. And he's sending messages back from Gemini 8. Can't you just hear the likes of Mr. Cochran and Mr. Scheck, if they had been in the control center down at Cape Canaveral when Colonel Borman sent messages thereafter? We can't believe that man. His credibility's been totally destroyed. And these photos he's sending of the moon, how do we know they're not fake? As I suggested earlier, it's not possible to call a great number of witnesses to the stand testifying to a great number of events without there being some discrepancies and unanswered questions here and there. But of course, the defense theory during this trial is that if the prosecution doesn't call robots and computers to the witness stand, if we only call human beings, somehow or other, that means that Mr. Simpson did not stab Nicole Brown Simpson and Ronald Goldman to death on the evening of June 12th, 1994. But if they want to play a game like that, ladies and gentlemen of the jury, let them play it by themselves. A classic example of the defense taking a small unanswered question and blowing it completely out of proportion arose out of the testimony of Dr. Henry Lee. This will be a little detailed, but I think it will be worth our while to discuss it because I think it illustrates a very important point. You recall that Dr. Lee found 4 small blood stains on a paper bindle that enclosed 7 cotton swatches that contained blood from item number 47, one of the 5 Bundy blood drops, which has been identified by DNA tests, of course, as belonging to Mr. Simpson. Lee couldn't figure out how the blood could have leaked onto that paper bindle in view of the fact that the swatches had been left out to dry overnight before they were placed in the bindle. The fact that there was no assurance at all that the blood on all of these 7 cotton swatches dried completely overnight, or that there was some other innocent explanation, did not deter Dr. Lee from saying, quote, "There's something wrong." And the defense has asked you to believe that what was wrong here is that evil LAPD conspirators crept into the LAPD crime lab in the middle of the night and planted or tampered with evidence. But there was nothing wrong here. Apart from the possible innocent explanation that I've already given you, here's the proof that whatever happened was totally innocent. As we saw from the evidence on that very same day at the crime lab, item number 42, some of Nicole's blood taken from the pool of blood around her body, also leaked onto the separate paper bindle enclosing the swatches that contain the blood. And no one would be crazy enough to argue, would they? No one would be crazy enough to argue that these evil LAPD conspirators would be creeping into the crime lab in the middle of the night and tampering or planting Nicole's blood. I mean, it was Nicole Brown Simpson who was found murdered at the crime scene, wasn't it? I mean, no one's questioning that fact. No one's that crazy, are they? So we know that there was a totally innocent explanation for those 4 small blood stains that Dr. Lee testified to. Yet the defense has seized on this tiny, tiny supposed discrepancy, a very small part of their entire case, as the mantra for their entire defense. Taking Dr. Lee's something wrong testimony about this very small part of the case and treating it as if it were a description of the prosecution's entire case. But you see, ladies and gentlemen of the jury, you make mountains out of molehills. You seize on tiny discrepancies. You split hairs. You look at the bits and the crumbs and the particles of a case. If what? If you know your client is guilty and there's nothing else for you to do. You certainly don't look at the incriminating evidence in the case. These defense attorneys had no more desire to look at the real evidence in this case than one would have a desire to stare into the noonday sun. And if I were they, I wouldn't either. Because all of the evidence, not some of it, all of it, points irresistibly to this man's guilt. Since Mr. Cochran and his colleagues have no legitimate defense to these murders, they and their client, Mr. Simpson, have also predictably, floundered aimlessly around, throwing out for your consideration one flat-out contradictory allegation after another, hoping, praying that at least one of them would stick on the walls of your mind. For instance, Mr. Cochran first suggested to you that Colombian drug lords, who, by the way, Forbes magazine said are among the wealthiest people in the world with net worths of several $billion, Colombian drug lords may really be the ones responsible for these murders. And who were they after? Not Nicole, but Faye Resnick, Nicole's friend. And they confused Faye Resnick with Nicole, who bears absolutely no resemblance to Nicole, and murdered poor Nicole. Colombian drug lords, among the wealthiest people in the world, and they're after Faye Resnick because she owed them money on her $30 a day cocaine habit. You know, I should add, and this is unimportant here, because the whole notion of Colombian drug lords going after Faye Resnick is just insane on its face, that not only did Faye Resnick testify that she didn't owe anyone a penny for her drugs, but we gave the fellow who sold Faye Resnick her small daily amount of drugs immunity from prosecution. He took the witness stand and told you folks that Faye Resnick always paid cash for her drugs and never owed him anything at all. Later in the trial, Mr. Cochran changed his story about who killed Ron and Nicole by suggesting that the true killer or killers were probably after Ronald Goldman. Not Faye Resnick now. All of a sudden now it's Ronald Goldman. Because of an envelope that Mr. Goldman brought with him, the contents of an envelope that he brought with him to Bundy that night. Another example. These are examples of these flat-out contradictory allegations. Just giving you two. First is Colombian drug lords, then people after Ronald Goldman. Colombian drug lords after Faye Resnick, killers after Ronald Goldman. Two completely contradictory allegations. Another example. In Mr. Cochran's opening statement to you folks, you recall that he told you that Mr. Simpson was practicing his golf on the front lawn of his Rockingham estate around the time of the murders. But Mr. Simpson told Ellen Park, the limo driver in this case, that he was sleeping around that time. A further contradiction. When Mr. Simpson was interrogated by Detectives Lang and Vanatter the day after the murders, he said nothing about playing golf or sleeping at the time of these murders. Nothing about playing golf or sleeping at the time of these murders. What he did say, he was very, very busy, he said, packing and getting ready for his trip to Chicago. You know, the flip-flops and these absolute contradictions by these people, absolute contradictions throughout the entire trial, remind me of a story that people tell about a civil case years ago. Seems that the plaintiff sued his neighbor, alleging that while he was walking on the sidewalk in front of his neighbor's home, the neighbor's dog had run out into the sidewalk and bitten him, caused injuries. The neighbor filed an answer to the complaint, and he set forth 3 contentions. First contention: my dog is chained to the house. The chain doesn't extend out to the sidewalk, so there's no possible way that my dog could have bitten the plaintiff. Number 2, my dog is an old dog. He doesn't have any teeth, so even if he did bite the plaintiff, there's no possible way he could hurt him. And number 3, I don't even own a dog. That's the defense in this case. That's the defense in this case. One contradictory allegation after another. They can't tell a story the same way, ladies and gentlemen of the jury, the same way twice. And that's because Mr. Simpson murdered the 2 victims in this case, and when you tell a different story that you made up, you don't have the truth, what really happened, the actual event, to serve as a basis, a mental anchor, as it were, for what you're saying. I'm sure you've all heard the expression, a liar has to have an awfully good memory. It's much easier to remember an actual event than some story that you made up out of whole cloth. Mr. Simpson, because he committed these murders, has no choice but to lie. And these defense attorneys, because they have no case, have no choice but to come up with one outrageous allegation after another to defend this man. Now, should any of you be saying to yourself, gee, you know, these defense attorneys don't have anything to argue, except smoke and mirrors, of course, except smoke and mirrors. But they don't have anything to argue. They don't have any case. I almost feel sorry for them. Should any of you be thinking that about these defense attorneys? No case, nothing to argue. But of course, ladies and gentlemen of the jury, although sympathy and sorrow should not and cannot, under the law, cannot under the law enter into your deliberations in any way in this case, if it were allowed, which it is not, obviously, the only 2 people that anyone should feel sorry for in this case are Nicole Brown Simpson and Ronald Goldman. And of course, they're survivors who are going to be having nightmares for the rest of their lives over what happened to their loved ones. We can't ever forget, so easy during a trial with all the testimony and talking about mathematical formulas and computations, so easy to forget what this trial is really all about. We cannot forget what this trial is all about. It's about murder. Murder. The most serious crime in the Bible. The most serious crime in the laws of man. At this very moment, while I'm talking to you folks, 2 precious human beings, Ron and Nicole, are decomposing in their graves. And the evidence that came from that witness stand under oath proves beyond all doubt that Mr. Simpson is the one who brutally murdered them. 2 young people in the springtime of their lives who desperately wanted to live. And this man here says, no, you're going to die. And my job here, representing the people of the state of California, is to bring about justice in this case, to make sure that this man does not walk out of this courtroom a free man. The defense in this case felt that Mark Fuhrman was going to be their savior, manna from heaven. They felt they could paint Mark Fuhrman in your eyes as this supreme racist who was the main LAPD officer who had framed their client because he was a black man. But as we've seen at this trial, turns out that Mark Fuhrman's not that bad a guy. Not that bad a guy. Graduated number 2 in his class at the police academy. Only 4 citizen complaints against him in close to 20 years. Not an excessive, unusual amount of complaints for close to 20 years. Apparently used to have racist tendencies. No question about that. But those Furman tapes, as you know, go all the way up to 1994. And the last time Mark Furman used the racial slur nigger on those Furman tapes, 1988, 6 years earlier. There was an entire 6-year period when Mark Furman made no racist remarks on those Furman tapes. Let's not forget that. 6 years. In 1994, Mark Furman had some black friends, one of whom, Danette Myers, Deputy District Attorney here in the DA's office, testified that on several occasions Mark Furman had her over to his home for dinner with his wife and 2 children. We know that Furman in 1994 was getting up 2-3 days a week at 5 in the morning to play basketball with fellow black officers. And most importantly by far, we learned that in early 1994, just months before these murders, Mark Furman wasn't out there framing black people. He was working hard to free a black man by the name of Eric Harris, who was charged with the murder of a white man, Sean Stewart, for a West Los Angeles killing that arose out of a drug transaction. And as we know, he succeeded. When Furman came upon evidence favorable to Harris, what does he do? He comes down to the DA's office and gets my office to dismiss the charges against Harris. You heard what Harris said from that witness stand. I was a goner, he said, if it hadn't been for that man, referring to Mark Furman. Is that what racists do who hate black people? Work hard to free a black man charged with the murder of a white man? It's so ridiculous it's silly to even talk about it. And yet the defense attorneys are asking you to believe that, among other things, Mark Furman planted that bloody glove from the Bundy crime scene at Rockingham in an effort to frame this man for 2 murders. Well, number one, even if Mark Furman wanted to plant that bloody glove, which, as is clear from what I just told you folks, he never in a million years would have wanted to do, but even if he had wanted to, he couldn't have. Why do I say that? Well, you know why. You heard 14 LAPD officers testify from this witness stand under oath that there was only 1 glove at the Bundy crime scene. And they arrived there before Mark Furman did at 2:10 in the morning. And they saw only 1 glove. So there was no second glove at Bundy for Mark Furman to pick up and deposit at Rockingham. I'll repeat this. There was no second glove at Bundy for Mark Furman to pick up, take over to Rockingham, and plant there. To buy the defense argument that there were actually 2 gloves at Bundy, and Mark Furman picked one of those gloves up and brought it to Rockingham and planted it, you'd have to believe, I think necessarily, some conversation would have had to have taken place here between Mark Furman and the 14 LAPD officers who took that witness stand and told you folks that there was only 1 glove at Bundy. He must have had a conversation with them to this effect. These may not have been the exact words, but to this effect. Listen, I don't know all you guys. You're uniformed. I've been working detective for quite a few years, but here's the skinny. I've got this thing about blacks, particularly when they're sleeping with a white woman, as Simpson was. And you know, I'd really like to see this SOB go down. So I need you guys to help me out, to back me up, testify on that witness stand that there was only 1 glove at the Bundy murder scene. Okay? I'll owe you one. For there actually to have been 2 gloves at Bundy when Furman arrived there, wouldn't a conversation at least similar to that have had to take place? But are we really to believe that not only did Mark Furman lie on that witness stand, but that he got 14 LAPD officers to commit perjury for him? That with absolutely nothing to gain on their part, they agreed to jeopardize their careers and risk going to the state prison just to help him out? When several of them told you folks that prior to that night, they had never even met Mark Furman. And they're going to risk going to the state prison? 14 LAPD officers? I mean, is there any limit to the insanity these defense attorneys would want us to believe in this case? Before I move on, I'd like to touch on a very rich irony here. The defense wants you to believe that Mark Fuhrman is this virulently racist white cop whom black people should hate and detest with a passion. And of course they want you to believe that O.J. Simpson should be a hero to blacks. But for several long and gritty years, Mark Fuhrman used to work South Central, which we all know is almost exclusively black. Several of you folks right now live in South Central. And you know that it has the highest violent crime rate in the city. So you know, much better than I, that South Central can be a dangerous area of town, particularly at night. What was Fuhrman's job? For a barely livable wage, going down there every day to protect black people, from the criminal element. In other words, on a day-to-day basis, and frequently working graveyard, Mark Fuhrman, the supposed racist black hater, was willing to risk his life to protect black people, not white folks, because white folks don't live in South Central. What was the defendant in this case, Mr. Simpson, doing during the same period? The evidence has showed that he was living and moving exclusively in the safe and protected and luxurious world of affluent whites. It's kind of an interesting irony to think about. Mark Fuhrman is down South Central protecting black people from the criminal element, risking his life. Of course, the defense claim of a conspiracy to frame Mr. Simpson has gone far beyond Mark Fuhrman. If we are to believe Mr. Cochran, Mr. Scheck, and Mr. Bailey, Mr. Shapiro has not made his position clear in this case. All 4 LAPD detectives, as well as virtually every other member of the LAPD involved in the investigation of this case, either participated in the framing of O.J. Simpson or participated in the cover-up of the frame-up. Let's talk about the 4 detectives in this case for a moment. To believe this ridiculous, preposterous conspiracy frame-up theory propounded by these defense attorneys in this case, you'd have to believe that these 2 teams of LAPD detectives, Lang and Van Adder, Fuhrman and Phillips, different divisions of the LAPD, Lang and Van Adder, downtown robbery homicide, Fuhrman and Phillips, West LA division, didn't work with each other, didn't even know each other. And they arrive at the murder scene in the middle of the night, and suddenly all 4 of them agree that whoever killed these 2 poor people, they didn't care. They were going to let the true killer or killers go. They couldn't care less. And suddenly they all decided, no dissents, to frame, of all people, O.J. Simpson. Someone who we learned at this trial was a friend of the LAPD. He's a friend of the LAPD. He'd go to their Christmas parties at the West LA Division, autograph footballs. Several of them swam in his pool, played tennis on his courts. I mean, even if the police were to frame a black man, O.J. Simpson would be one of the very last black men on the face of this earth whom they would have framed. Here's someone they had always liked, even pampered. Recall Nicole's anguished cry to the LAPD officers who responded to her 9/11 call in 1989. You come out, you talk to him, but you never do anything to him. So they wouldn't even arrest this man for wife beating, but they're willing to frame him for murder. I've always had a sweet tooth for the symmetry of logic like that. I'm being sarcastic, of course. You know, they say that when you get older, you're supposed to become more mellow. But with me, it seems to be the opposite. The older I get, the more sarcastic I seem to be getting. But stop to think about it, ladies and gentlemen. Here's someone that the LAPD not only likes, no question about that. They liked O.J. Simpson. But he's someone who's a multimillionaire, lives in a wealthy, virtually all-white neighborhood, moves and socializes exclusively in the white corporate and establishment worlds with powerful connections, why would they want to mess with someone like that? Why would they want to mess with someone like that? You jurors, particularly those of you who are black, know that this defendant is black in color only. I mean, he'd need a road map to get back to the hood. Yet according to these defense attorneys, these LAPD detectives set out to frame him for these terribly brutal, gruesome murders because he's a black man. Just because he's a black man. And in the process, not only jeopardize their careers, but risk their very lives. Because under Section 128 of the California Penal Code, you plant evidence and testify falsely in a capital case. And under some circumstances, you can get the death penalty yourself. Although this case ended up not being a capital case, because my office decided not to seek the death penalty against him, at the time of the alleged frame-up, the night of the murders and shortly thereafter, with these two terribly brutal, savage murders, the 4 detectives in this case would have had every reason to believe that whoever the killer turned out to be, my office would seek the death penalty against that person. And when several of these officers later testified at the preliminary hearing in this case, my office had not yet decided not to seek the death penalty. So if they testified falsely at that preliminary hearing, they were risking their very lives. Phil Van Adder, 26 years on the force. Not one citizen complained against him in 26 years. About to retire in a couple months with his wife Rita to their farm in Indiana. And he's going to risk his good name and his pension and possibly his very life to frame this man, O.J. Simpson? I wouldn't believe a story like that if you shouted it in my ears for 100 years. And yet that's precisely what the defense in this case wants you folks to believe. And why were these officers willing to risk their lives, risk going to the gas chamber to frame this man? What was in it for them? What was their motive? Well, I don't know. I guess they were upset with him because he was born black. Or maybe it was because he married a white woman. Anyone who would believe an incredible fable like that would believe someone who told them they once saw an alligator doing the polka. Is there anyone in this courtroom who doesn't realize how absolutely and utterly and completely insane it is to believe that all 4 of these detectives, or even one of them, would jeopardize their careers, risk their very lives to frame this man for these murders? How dare these defense attorneys accuse these officers of framing an innocent man for murder? The foulest, most despicable deed, most reprehensible deed that any human can do to another human being, short of murder. I mean, where do they get the guts to make a charge like that? Where do you buy guts like that? I haven't seen any guts like that in storefront windows here in L.A. Maybe Mr. Scheck brought them with him when he came from the Bronx. These defense attorneys have elevated audacity to previously unimaginable heights. To show you just how preposterous the defense conspiracy theory is, even if the 4 LAPD detectives had wanted to frame O.J. Simpson, which of course itself is a preposterous notion, but even if they had wanted to, it would have been virtually impossible. And I'll tell you why. The number of people who would have had to have been involved in this massive conspiracy and the complexity of what they would have had to have done is simply mind-boggling. To give you just an example of the complexity, the dark cotton sweatsuit that Cato Kalin, you heard him testify, he saw this man, this defendant, Mr. Simpson, wearing less than 1 hour before these murders, has never been produced by the defense in this case. So for dark cotton fibers to end up on Ron Goldman's shirt, as they did, the detectives would have had to go out, buy a dark cotton sweatsuit, remove fibers from it, check Ron Goldman's shirt out of the property division of the LAPD, and then embed those fibers into Ron Goldman's shirt. They'd likewise have to remove fibers from the carpet of Mr. Simpson's Ford Bronco, check the glove found on the Rockingham estate out of the property division, and embed those fibers into that glove. 9 black hairs with the same microscopic characteristics as Mr. Simpson's hair were found inside a black knit cap found near the bodies of the victims. A 10th hair like this was found on Ron Goldman's shirt. 100 hairs were removed by court order from Mr. Simpson's head for comparison purposes. So without the defense attorneys noticing that any hairs were missing, the detectives would have also had to take 10 of those hairs from the bindle containing the 100 hairs and embed 9 of them into the dark knit cap and 1 of them into Ron Goldman's shirt. And so on with a great number of other pieces of evidence in this case. A person would have to have a brain smaller than the point of the finest needle to believe nonsense like that. As to the number of people that it would have had to be involved in this massive conspiracy, in addition to the 4 detectives and the 14 uniformed LAPD officers who Mark Furman supposedly got to lie, commit perjury on the stand for him, these conspirators, if there was a conspiracy, would have necessarily also had to persuade all the civilian criminalists at the LAPD crime lab, like Dennis Fung, Andrea Mazzola, Colin Yamauchi, Greg Matheson, to join in the conspiracy to frame this man. Also, they also would have had to enlist into the conspiracy all the criminalists who worked on this case at the State Department of Justice lab at Berkeley and the Cellmark lab in Maryland. Why do I say that? Because if they didn't enlist all of these criminalists at those 3 crime labs, not only would the conspirators have had to plant all the incriminating physical evidence against this man, they'd also have to be successful in eliminating all the physical evidence that may have been left behind by the true killer or killers. Right. You can just picture Detectives Tom Lang, Phil Van Adder, Ron Phillips, and Mark Furman huddled at the Bundy crime scene in the middle of the night. And I can just hear Phil Van Adder say, "Listen, Tom and I will round up all the hair, fiber, and blood belonging to Mr. Simpson that we need and plant it. You guys scrounge around and find and destroy, eliminate all the hair, fiber, and blood that may have been left behind by the true killer or killers. Let's all meet over coffee at McDonald's at 6. We'll compare notes." Well, you know, it sounds a little funny, but without that conversation, or something close to it taking place, the conspirators would have had to worry. The conspirators would have had to worry about reports coming back from the criminalists saying that unidentified hair, fiber, and blood was found all over the crime scene. And of course, once those reports started coming back to people outside the conspiracy, like myself, colleagues of mine down at the DA's office, it would just be a matter of time, of course, before the frame-up would be exposed, the jig would be up, and the careers and the lives of these conspirators would then be on the line. If there had been a conspiracy here, the only way for the conspirators to have precluded this would have been for them to enlist all of these criminalists into the conspiracy to frame this man. You can just picture a chemist at the Cellmark lab back in Maryland. He's peering into his microscope and the phone rings. It's some LAPD detective from LA saying that we're framing O.J. Simpson. And therefore, if any hair, fiber, and blood not belonging to Mr. Simpson turns up, don't put it in your reports. Ladies and gentlemen of the jury, is all of this defense argument about a police conspiracy and a frame-up, is it sanity or is it insanity? Is it sense or is it nonsense? I think everyone in this courtroom knows the answer to that question. Just one very small addendum to this discussion. If there was this massive conspiracy to frame this man, involving a considerable number of people, how come not one word about it has leaked out? Not one word. We all know from our own experiences, and you take your own experiences back to the jury room. When you deliberate, you don't leave your experiences at the jury door. We all know from our experiences that it's almost impossible to keep a secret. People have a funny habit of talking to their spouses, to their colleagues, to their friends, who in turn talk to others. I'll stipulate, I'll agree. 3 people can keep a secret. I'll agree with you on that, but only if 2 are dead. In this case here, almost an entire year and a half has gone by. And yet with all these people supposedly involved in this conspiracy to frame this man, not one word, not one syllable has leaked out. Just one other indication of how nonsensical and ridiculous this whole police frame-up theory is. Do you folks realize that we have the incredibly ridiculous situation here? And by the way, I have to apologize to you for using the words like ridiculous and preposterous so much to describe these defense allegations. But in my partial defense, I hope you folks realize that there aren't too many adjectives for me to use to describe these outrageous allegations other than words like ridiculous, preposterous, absurd. Anyway, I was saying that we have the incredibly ridiculous situation here, where Mr. Simpson's defense attorneys are claiming that he was framed for these 2 murders, but not even their own client, Mr. Simpson, agrees with them. If you know you're completely innocent of a crime, and all of a sudden there's a ton of evidence that turns up against you, pointing towards your guilt, you immediately know that you're being framed. Yet Mr. Simpson has never told anyone or even vaguely suggested to anyone such a thing. If he knew or suspected that he was being framed, wouldn't he have said so in that 32-minute interrogation of him by Detectives Lang and Van Adder the day after the murders? Wouldn't he have said so in the farewell letter he wrote several days later when he learned he was going to be charged with these murders? Wouldn't that have been the most natural thing in the world for him to have done in that farewell letter if he thought he was being framed? And during the slow-speed chase, when he was talking on his cellular phone with the police, his mother, his friends, he said nothing at all about being framed. Not one word. In fact, at the end of that slow-speed chase, when he was taken into custody by Detectives Lang and Van Adder, he said, "I'm sorry, you guys, I'm sorry." He kept telling them that he was sorry for having led them on a chase. Is that what you say to people who you believe are framing you for a murder, that you're sorry for putting them out? I mean, when you're being framed for murders that you did not commit, don't you shout this from the highest rooftops that you're being framed? Yet in all these times I've told you about, with all the opportunity in the world for him to say so, not once did this man say one word about being framed. Mr. Simpson's lawyers want you to believe something then that their own client, Mr. Simpson, does not believe. There ought to be a law against things like this. Quite apart then from all the scientific DNA evidence that conclusively proves this man's guilt beyond all doubt, other than his getting up in court right now and confessing to you folks, he has already told you by his words, by his actions, that he's guilty of these 2 murders. I mean, if Mr. Simpson were innocent, How did these LAPD conspirators get him to act in such a guilty way? How did they get him to act like the guiltiest person imaginable? Did they come up to him and say, "O.J., we're going to frame you, but we need your help, old buddy. We need you to act guilty"? And he said to them, "No sweat. Tell me what you guys need. Tell me what you want." If Mr. Simpson were innocent, how did these evil LAPD conspirators, how did they get him to tell that monumental lie to the limo driver, Ellen Park, that I just got out of the shower, I overslept, just got out of the shower, I'll be right down, when Mr. Park had just seen him enter his home a couple seconds earlier? How did they get him to tell that lie? If Mr. Simpson were innocent, how did these evil LAPD conspirators get him when Sergeant Phillips called him in Chicago 8 hours after the murders to tell him that Nicole had been killed, not murdered, just killed? It could have been a car accident. Phillips didn't say. How did they get this man not to ask Phillips, how did it happen? When did it happen? Where did it happen? He asked none of those questions. How did they get this man to write a suicide note? If he's innocent and they're framing him, and then 2 days later, how did they get him to flee with his friend Al Collins in that Bronco? With a gun, a passport, and a disguise. Again, if there was a police conspiracy in this case to frame Mr. Simpson, and he was innocent, how did they get him to act so guilty, to be such an extremely cooperative framee? Did Mr. Simpson, by any chance, decide to join in the conspiracy against himself? About that suicide note. When Mr. Simpson learned he was going to be charged with these murders, if he were innocent, he would have been outraged that he was being charged with murders that he did not commit. How dare you accuse me of these crimes? He would have desperately wanted to prove his innocence. Find out who murdered the mother of his own 2 children. Instead, he doesn't do any of these things. No, he becomes completely passive. And he writes this "to whom it may concern" farewell letter that reads exactly like a suicide note, and refers to himself as this, quote, "lost person." The letter reeks with guilt. Show me an innocent person on the face of this earth charged with 2 counts of murder who would write a note like that. Why did the defendant write the suicide note on June 15th, 1994? 2 days later, of course, he decided after all that he did want to live, and he fled in the Bronco with Al Collins. But why did he write that suicide note on June 15th, 1994? Obviously, only Mr. Simpson knows why he wrote that note. It's to speculate on human motivation. I think you all agree is a rather unprofitable undertaking. Only he knows why he wrote that note. The only thing we know is that it was not the conduct of an innocent man charged with the murder of his former wife. But if I had to speculate, he probably had a perverse type of love for Nicole. And was very, very deeply depressed that he had murdered her. Another likely thought in his mind, if I had to speculate, is that he had committed these 2 unbelievably horrendous murders, and he didn't want to face the enormous public humiliation, nor did he want to pay for these murders. Perhaps he may have even thought in the gas chamber at San Quentin. He wanted to go out his way. But as it turned out, my office decided not to seek the death penalty against him. Of course, he would have had no way of knowing this at that time. I've been pointing out to you that this defendant's fleeing with Mr. Collins and Collins' Bronco can only be consistent with guilt, not innocence. But what the police found in Mr. Simpson's possession at the end of that slow-speed chase, if possible, is even more incriminating.
a loaded Smith & Wesson gun, his passport, a disguise in the form of a fake goatee and mustache, 4 pairs of folded socks, 4 T-shirts, and 2 pairs of underwear. In other words, Mr. Simpson was leaving town. He was leaving town. Or if he was going to stay here, he certainly was going to stay incognito. And we all know that's the way innocent people act. Of course that's the way they act. They either run away or they stay in town and they put on a disguise so no one will recognize them. Additionally, Mr. Cowlings, at the end of that slow-speed chase, the detective noticed that his pockets were bulging. They asked him to empty out his pockets. He removes $8,750 in currency, which he proceeds to tell the detectives that Mr. Simpson had given him inside the Bronco. All of this couldn't possibly be more powerful evidence of guilt. I mean, the passport alone. Why does this guy have a passport on him unless he's thinking of escaping? And why is he thinking of escaping if he's innocent? Why is this defendant, Mr. Simpson, thinking of escaping if he's innocent? I mean, this man's guilt is so obvious, folks, that I'm almost embarrassed standing up here in front of you folks talking about it. But he pled not guilty, which he has a legal right to do, and so I must do what I'm doing to make double and triple sure that he doesn't walk out of this courtroom a free man. Before I move on, I want to mention one very, very intriguing date in this entire saga. In the Bronco, right alongside the fake goatee and mustache in his traveling bag, was the receipt for the purchase of these items from the Cinema Secrets Beauty Supply, 4400 Riverside Drive in Burbank. The date that these items were purchased by Mr. Simpson is what is so incriminating. It was May 27th, 1994, just over 2 weeks prior to these murders. And as we learned from Faye Resnick, just a few days after Nicole gave back to Mr. Simpson earrings and a bracelet he had given her for her birthday on May 19th, telling him that their relationship was finally and irrevocably over. As Judge Ito will instruct you, the prosecution does not have the burden of proving why this defendant committed these murders. Motive is never an element of the corpus delicti. That means the essential necessary elements of any crime. The prosecution only has to prove that the defendant committed the crime, not why. But Faye Resnick, we know, was a confidant of both Nicole and Mr. Simpson near the end. In fact, she lived with Nicole near the end. She and other witnesses have testified about the rocky, tempestuous relationship that Mr. Simpson had with Nicole, and the fact that Nicole had left him on previous occasions, but then would reconcile with him. But always in the past, Ms. Resnick testified, when Nicole would leave Mr. Simpson, she would tell him that she still loved him, and that she was only leaving because they couldn't get along. They were just incompatible. I think we can reasonably infer from that as long as Mr. Simpson knew that Nicole still loved him, she was still his. He still owned her. And in his mind, he was confident they would have another day. But this time, Ms. Resnick testified it was different. Nicole, she said, felt free for the very first time since she had fallen in love with Mr. Simpson years earlier. She was finally able to sever the umbilical cord between herself and Mr. Simpson because Ms. Resnick testified Nicole no longer loved him, and he knew it. Now, the defense in this case, as you know, has tried to convince you folks that Mr. Simpson wouldn't have had any reason to kill Nicole because he was over her and had started a new life without her. The probable reality, however, is that he was not over her and that he killed her because she was over him. It was finally over, and whether he truly loved her or not, he may not have been able to take it. He couldn't take the rejection of him. In fact, Miss Resnick testified that on 2 occasions after Nicole left Mr. Simpson for the last time, Mr. Simpson told Miss Resnick that if Nicole dated within a certain period of time, I'm going to kill that bitch. I hate to resort to cliches, but sometimes they speak of essential truths. In this case, if I can't have Nicole, no one else ever will. And of course, Mr. Simpson saw to it that no one else would ever be with Nicole. Again, we don't have to prove this defendant's motive for killing Nicole. All we have to prove is that he did it, and we certainly have done that. But for those of you on the jury who might wonder why he killed Nicole, and at this particular time, I would suggest to you that Ms. Resnick's testimony has merit. One final point about Mr. Simpson's purchase of the disguise. There's an old observation you probably have heard that celebrities are people who spend an enormous amount of time and energy becoming well-known and famous, and then when they do become well-known and famous, they wear dark glasses or a disguise so no one will recognize them. But unfortunately for the defense in this case, they can't use that argument as a reason for Mr. Simpson buying that disguise. By all accounts, Mr. Simpson loved it when people recognized him. Faye Resnick testified she was with Nicole and Mr. Simpson many times in public. And she said that whenever he wasn't recognized, quote, his mood would change and he would become angry. Mr. Simpson himself, in his own book, O.J., The Education of a Rich Rookie, says about his celebrity, quote, I loved it when people recognized me on the street. So why then did Mr. Simpson suddenly find it necessary, shortly before these murders, to buy a disguise? Let's discuss now the second theory that these defense attorneys have asked you to accept, namely garbage in, garbage out. If they say the blood evidence in this case, they're referring to that blood evidence that was not planted by evil LAPD conspirators. If this remaining evidence had become contaminated by bacteria, exposure to the elements, etc., which they want you, of course, to believe actually happened, this blood became garbage. And when this garbage was submitted to the 3 crime labs in this case, it could only yield a garbage result. Hence, garbage in, garbage out. Yes, if blood is sufficiently contaminated, it will become garbage and yield a garbage result. But the critical question is, the seminal question is, what will that garbage result be? We had testimony at this trial from Dr. Robin Cotton, lab director at Cellmark, uncontroverted by any experts from the defense, that contamination will yield an inconclusive result. That's what the garbage result will be, an inconclusive result. It will not, she said, and she didn't have to tell us this, common sense would tell us this. It will not cause the blood of one person to be identified as the blood of another. In other words, it won't give you a DNA match. I don't care how much experience Mr. Scheck has in trying DNA cases. He can search from now until the cows come home. And unless it's at gunpoint, he's not going to find any DNA expert anywhere in this entire country who's going to take the witness stand and testify that contamination can turn one person's blood into another. Again, I agree, garbage in, garbage out. But we know there was no garbage in this case because if there had been, there would have been garbage out. I.e., there would not have been a DNA match between the blood found at the murder scene and the blood removed from Mr. Simpson's body. The DNA test would have yielded an inconclusive result. Stated another way, the fact that there was a DNA match in this case is conclusive proof that there was no contamination. Because if there had been contamination, there would not have been a DNA match. In reality, then, garbage in, garbage out is a prosecution argument, not a defense argument, as these defense attorneys have boldly tried to make it. For instance, in a case where the prosecution is convinced from all the evidence that it must be the defendant's blood at the murder scene, I can see the prosecution arguing that the reason they can't get a DNA match is because the blood became contaminated, and the contamination prevented the DNA match with the defendant's blood. Since garbage in, garbage out is so obviously and clearly and unequivocally a prosecution argument, to argue it as a defense theory, as these defense attorneys have done throughout this entire case, is so patently transparent that a blind man could see through it. Yet that's what these defense attorneys have shamelessly argued to you throughout this whole trial. I mean, if they'd at least blush, maybe it wouldn't bother me so much. I don't know if it's appropriate to use a term like this in a courtroom, but I tell you, these defense attorneys have the gonads of 10,000 elephants. And at the end of this trial, I'm going to ask them for their autographs. They're unbelievable. Garbage in, garbage out, being a defense theory, a defense argument. They're unbelievable, these people. It's a prosecution argument. Ladies and gentlemen of the jury, the evidence of Mr. Simpson's guilt is so obvious and so overwhelming in this case that you could throw 80% of it out the window. Throw it out the window. There'd still be no question of this man's guilt. For instance, we know that this defendant beat Nicole severely to the point where she feared for her life at his hands. Recall her telling Officer Edwards, "He's going to kill me. He's going to kill me. He's going to kill me." Throw it out the window. Let's assume they got along well, just swimmingly. He never laid a hand on her. Throw it out the window. We don't have that evidence anymore. When he learns he's going to be charged with these murders, as I've said, if he were innocent, he would have been blazing mad that he was being charged with murders that he did not commit. And above all, want to prove his innocence and find out who murdered the mother of his 2 children so he could see that person brought to justice. Instead, he writes that suicide note that absolutely reeks with guilt. Throw it out the window. We don't have it anymore. He didn't write a suicide note. 2 days after the suicide note, when he was scheduled to turn himself in to be formally booked on these murder charges, he instead flees, runs away with his friend Al Cowlings in Cowlings Bronco. His fleeing, his running away, obviously, clearly shows a very distinct consciousness of guilt. Throw it out the window. We don't have it. He didn't run away. After the slow-speed chase, they find the gun, the passport, and the disguise in his possession. We already know what all of these things mean. Again, they just absolutely reek with guilt. Throw it out the window. We don't have it. Can't use it against them because we don't have it anymore. On the night of the murders, Ellen Park, the limo driver, arrives at Rockingham, 10:22 p.m. She's supposed to pick up Mr. Simpson at 10:45 p.m. for the trip to LAX. Incidentally, I think we can rely on Mr. Park's times because knowing the exact time, I think, is a limo driver's stock and trade, as it were. Park testified that between 10:40 and 10:50 p.m., goes to the gate at the Rockingham estate, rings the buzzer, no one answers from 10:40 to 10:50. Several times he goes to the gate. At 10:55 p.m., he sees a black person, he doesn't know whether it's a man or a woman, weighing about 200 pounds, 6 feet tall, wearing all dark clothing, walking briskly up to the front door of the residence. He's wearing all dark clothing. As soon as the man enters the residence, immediately the light in the entryway is turned on. whereupon Mr. Park immediately goes back to the gate, rings the buzzer again, and this time Mr. Simpson immediately picks up the phone. So we know it was he whom Mr. Park had just seen enter the residence. What does this defendant tell Mr. Park? I overslept. I just got out of the shower. I'll be right down in a minute. It couldn't be more obvious what this defendant was trying to do. He was trying to set up an alibi for himself. What other reason under the moon would he have had to tell this blatant lie to Ellen Park if he hadn't just committed these two murders? Throw all that evidence out the window. We don't have it anymore. We can't use it against him. It doesn't exist. In fact, throw the bloody glove found on this defendant's estate with his, Ron's, and Nicole's blood on it. The glove that matches the glove found at the murder scene. Throw it out the window. We don't have it anymore. Can't use it against him. In fact, throw out all the DNA evidence that conclusively proves that it was this defendant's blood at the murder scene. His fresh blood at the murder scene. Throw this conclusive evidence of guilt out the window. We don't have it anymore. His blood was not found at the murder scene. Let's also throw out the DNA evidence that Ron's and Nicole's blood was found inside Mr. Simpson's Ford Bronco within hours of these murders. And Nicole's blood was found on his socks on the floor of his bedroom. Throw it out the window. Throw all of this evidence out the window we've been talking about. None of it exists anymore. And even if we throw all that evidence out the window, there's still no question that this man committed these murders. Why do I say that? Because this defendant, from his own lips, in effect, told us that he committed these murders. How did he tell us? Let's take it step by step. You heard his statement to the police on the day after the murders. We played it for you folks here in this courtroom. As you know, the detectives told Mr. Simpson that they found blood in his car and in his home and on his driveway. And when they asked him why that was so, this is the interview now they had with him the day after the murders. When they asked him why that was so, he said he had cut himself the previous night, the night of the murders, and he said that if they had found blood, quote, it's what I dripped running around trying to leave. I'll repeat that. Mr. Simpson told the police, it's what I dripped running around trying to leave, referring to his getting ready between 10 and 11 p.m. for his trip to LAX and his flight to Chicago. And of course we know from the testimony of several witnesses that the two murders in this case took place somewhere between 10:15 and 10:40 p.m. that night. So Mr. Simpson admits then that around the very same time of these murders, which was 16 hours or so before the LAPD removed any blood from his arm and would have had any opportunity to sprinkle or plant it, he admits that he's dripping blood in his car and home and on his driveway. So even if we bought, please try to follow me here, even if we accepted the absurd and the groundless defense allegation in this case that the police tried to frame this man by planting blood from his reference vial in various incriminating places, like his car and his home, it still couldn't be more obvious that he's guilty. Because whatever blood that they would have planted had to be in addition to blood of Mr. Simpson's that was already in his car, in home, and on his driveway on the night of these murders. Let me repeat this to you, since there's no way that I can emphasize its importance to you too much. Whatever blood the police may have planted in this case, which didn't happen, it's ridiculous to even talk about it. It's crazy to even talk about it. It didn't happen. But even assuming that they did plant blood, that blood would have had to be in addition to blood of Mr. Simpson's, which he admits was already in his car and home and on his driveway on the night of these murders. We know that because the defendant from his own lips told us so. He told us so. You heard the tape. We played it for you here in this courtroom. And as we heard on the tape, when the detectives asked him how he cut himself that night, these are his exact words, not a paraphrase, his exact words, "I don't know." Can you imagine that, folks? I don't know. Now let's just stop to think about this for a moment. We're not talking about a little nick or scratch here. We're talking about a deep cut to the knuckle of his left middle finger. It was heavily bandaged at the time they were talking to him, and he says he has absolutely no idea how he got that cut. That ridiculous statement, all by itself, shows an unmistakable consciousness of guilt. But there's an even more powerful reason why this defendant's own statement shows that it was he who on the evening of June the 12th, 1994, murdered the two victims in this case. What is the likelihood, I ask you? What is the probability? What is the probability that around the very same time that Ron and Nicole were brutally murdered, that this defendant would innocently cut himself very badly on his left middle finger? I would think that the statistical improbability against such a thing happening would be astronomical. I mean, aren't we talking about DNA numbers here? 1 out of 10 million? 1 out of 100 million? I want you folks to think back, not to when you were children, but to your adult life. It hasn't been too often, has it, that you've cut yourself badly, if at all? Last time I remember cutting myself was about 3 decades ago, 30 years ago. I was in the garage, working with a small electric saw, and I cut myself in my wrist. But it's not common, is it? It's not common that adults cut themselves badly. It's kind of rare, isn't it? Here in this case, Mr. Simpson just didn't cut himself badly within the same decade that his former wife was brutally murdered. Not just within the same year that she was murdered. Not just within the same month or even within the same week that she was murdered. In fact, not just on the same day that she was murdered. No. These defense attorneys want you folks to believe that around the very same time, within the same hour that she was murdered, he cut himself very badly. And to top it off, he says he has absolutely no idea how he got cut. Is there one reasonable person in this courtroom who would believe a ridiculous, cockamamie, preposterous story like that? Anyone who is so naive that they'd believe a story like that would believe someone who told them they once saw a man jump away from his own shadow. You know, even if we make the totally unwarranted, extremely extravagant assumption that his innocently cutting himself around the very same time of these murders was not totally and completely far-fetched, which we of course know it is. When you cut yourself, unless you're in a frantic, frenzied state, as Mr. Simpson obviously was in, you stop the bleeding with your hand or your handkerchief, and you put on a bandage, right? You don't bleed all over the place, do you? So I repeat, even if there were no other evidence in this case, this defendant, in so many words, and from his own lips, admitted committing these two murders. Within the same hour of these murders, by his own admission, he's dripping blood in his car and home and on his driveway. And he says he has no idea how he got cut. Before I go on, I should briefly recapitulate for you what I'm talking about when I say this defendant was bleeding all over his car, home, and driveway. Even excluding the inevitable blood drops that were not discovered and the blood of Mr. Simpson's found on the Rockingham glove, as well as the fact that criminalists do not pick up, they don't take samples from every blood drop and stain that they see, only taking what they call representative samples. Dennis Fung testified, the criminalist, that he collected 30 samples of blood from Mr. Simpson's Bronco, the interior of the Bronco, and on the outside of the Bronco, most of which he said were the defendants, some of which belonged to the two victims. Also, he testified there was one drop of Mr. Simpson's blood on the street right behind the Bronco where it was parked on Rockingham, one drop on the driveway just inside the Rockingham gate, 3 more drops of Mr. Simpson's blood on the driveway leading to the front door of the residence. Fung said that he didn't pick up 3 other drops that were there. There were 5 drops of Mr. Simpson's blood on the floor of the foyer inside his residence, and 1 drop on the bathroom floor. He also had blood of his on his socks in his bedroom. You folks might ask yourself that if you were to leave this courtroom right now and check your car and home, could any of you find even 1 drop of your blood, or anyone else's blood, even 1 drop, in your car or home, and fresh blood at that? Remember, the LAPD criminalist said this was all fresh blood. Ladies and gentlemen of the jury, jurors are not expected to possess supernatural powers. All that can be expected of you folks as reasonable men and women is that you conscientiously evaluate all the evidence in this case, apply your logic and your common sense and your reasoning powers, as well as the law given to you by Judge Ito, to that evidence, and thereby reach a just and a fair verdict. And when you do that in this case, you can only come to one conclusion, and one conclusion only, that this man here is guilty, that he committed these murders. There's absolutely no reasonable, rational explanation for what happened in this case, other than this man's guilt. None at all. Before I yield the lectern to defense counsel for their closing arguments, I'd like you to reconcile for us, Mr. Cochran, 3 completely contradictory statements which I've already alluded to in this opening argument of mine. In your opening statement, you told the jury that Mr. Simpson was practicing his golf in the front lawn of his estate at the time of these murders. But as you know, Mr. Simpson told the limo driver that he was sleeping around that time. It's a contradiction. The further contradiction is that when the LAPD detectives interviewed your client on the day after these murders, they asked him everything he had done that night. He said nothing at all about sleeping or playing golf. All he said is that he was racing around, very, very busy, packing and getting ready for that trip to Chicago. I want you to reconcile these 3 completely contradictory statements, and I want you to do so by confining yourself to the evidence and testimony that came from this witness stand under oath. When I later address you folks, I'll of course respond to what Mr. Cochran said, or comment on the fact that he refused to answer this question for you. Thank you very much, ladies and gentlemen. Let me reiterate how important the closing or rebuttal portion of final summation is for the prosecution. It's the climax of the case, where the prosecutor has his last and best opportunity to convince the jury of the rightness of his cause. A big error that both Clark and Darden made in their rebuttal arguments, and one that the overwhelming majority of prosecutors make, is that they confined their closing argument almost exclusively to merely answering or rebutting the defense arguments. But if you do that, your argument is almost necessarily defensive in nature and can actually end up becoming a negative, a liability. While it is true that in rebuttal the prosecutor can only respond to arguments made by the defense in their summation, neither Clark nor Darden apparently know that rebuttal does not have to be a restrictive summation at all. After the prosecutor has responded to and rebutted all the defense allegations, he has the opportunity to argue his entire case, in a condensed manner of course, all over again, thereby ending his case on a powerful affirmative note. All he has to do is quote the defense attorney's inevitable assertion that the prosecution did not prove the defendant's guilt beyond a reasonable doubt. This legally gives the prosecutor, in rebutting this contention, the right to cite all the evidence of guilt again that does show the prosecution met its burden of proof. However, in doing this, the prosecutor should draw new or expanded inferences of guilt.
This is what I would have done in this case. By the way, at one point, I'm going to be asking Johnny Cochran to stand up and respond to a question of mine. It will only be one of many I would have asked in a real trial. Of course, since Mr. Cochran is not participating in this video, his response, if any, will not take place. Join me now for the closing argument, the prosecution's rebuttal. Good afternoon, ladies and gentlemen of the jury. You know, as I was listening to Mr. Cochran and Mr. Scheck addressing you folks, I thought to myself that just like me, they went to law school. So I happen to know that although they learned the law in law school, they didn't learn how to be magicians. But even if they had, not even a Houdini can pull a rabbit out of the hat when there is no rabbit in the hat. Based on the evidence that came from this witness stand at this trial, their client is as guilty as sin, and there's nothing they can do about it. I have yet to meet the man that can convince 12 reasonable men and women, as you folks are, that black is white and white is black. I wonder if any of you folks have read Victor Hugo's account of the octopus. He tells us of how it doesn't have any beak to defend itself like a bird, no claws like a lion, no teeth like an alligator, but it does have what could be called an ink bag. And to protect itself when it is attacked, it lets out a dark fluid from that ink bag, making all of the surrounding water dark and murky, enabling the octopus to escape into the darkness. Now I ask you folks, is there any similarity between that description of the ink bag of the octopus and the defense in this case? Has the defense offered you any real, valid, legitimate defense to these murder charges? Or have they sought to employ the ink bag of the octopus, and by making everything dark and murky around Mr. Simpson, enable him to escape into the darkness? In this closing argument, I intend to clear up the water which defense counsel have sought to muddy, so that you folks can clearly see the evidence, the facts, the issues in this case, so that you're going to be able to behold the form of the retreating octopus and bring this defendant back to face justice. Before I respond in depth to Mr. Cochran's and Mr. Scheck's summation to you, let me point out that one fact alone, just one fact alone in this case, all by itself, proves this defendant's guilt beyond all doubt. As I said in my opening argument, when your blood is found at the murder scene, that's the end of the ball game. There's nothing more to say. And here, not only was Mr. Simpson's blood found at the murder scene, but the victim's blood was found inside his car and home. Under those circumstances, the question is not whether he's guilty or not guilty. Of course he's guilty. The question is it humanly possible, under those circumstances, for this man to be innocent? And the answer to that question is an unequivocal no, at least not in the world in which we live. You know, I'm talking to you folks, you can hear me, there's going to be a dawn tomorrow, that world. Only in a fantasy world can you have your blood at the murder scene and still be innocent. I mean, to deny guilt when your blood is at the murder scene is the equivalent of a man being caught by his wife in flagrante delicto with another woman and saying to her, quoting comedian Richard Pryor, "Who are you going to believe, me or your lying eyes?" It's that ridiculous. It's that ridiculous. Mr. Cochran argued to you that whatever domestic violence there was in this case by Mr. Simpson against Nicole during their years together was not relevant to these murder charges. Let me give you folks some proof that Mr. Simpson's history of physical abuse against Nicole is relevant to these murder charges. What if the evidence at this trial had showed that throughout the defendant's marriage to Nicole and in their years thereafter, they got along wonderfully, that he never once touched her in an offensive way or even yelled at her? We all know what Mr. Cochran would have argued to you folks. I can just about tell you his exact words.
It's ridiculous for the prosecution to allege that my client murdered Nicole. All their years together, they got along beautifully. Not once did he hit her, slap her, or even push her. And suddenly, out of a clear blue sky, he's going to pick up a sharp knife and stab her to death? It's ridiculous for the prosecution to say that. They know that's crazy. Surely none of you doubt that he would have made that precise argument to you if Nicole and his client had gotten along well during their marriage and during their years together. Since we know that Mr. Cochran would have made that argument to you if there had been no physical abuse, this is proof of the relevance of this evidence where there has been physical abuse. Now, I'm not going to suggest to you folks that just because a man beats his wife that he's likely to go on and kill her. Statistics show that's not so. But certainly, someone who has beaten his wife the way we know Mr. Simpson did, to the point where she thought he was going to kill her, is obviously much more likely to kill her than someone who had never once laid a hand on his wife. The French philosopher Voltaire tells us that common sense is not that common. But I think anyone with a head on their shoulders would have to agree that what I just told you folks is true. Although this domestic violence evidence we offered is not conclusive evidence of guilt, and it's not offered as being conclusive evidence of guilt, it's just one more piece of evidence which, together with all of the other evidence in this case, adds up to a clear and inescapable mosaic of guilt. In fact, no evidence in this case points towards this man's innocence. Everything points towards his guilt. Remarkably, there's not a sliver, an iota, a particle of evidence, nothing at all that points towards his innocence. Mr. Cochran, in his argument to you, told you that the prosecution's case against Mr. Simpson was only one of circumstantial evidence. That is, no eyewitnesses, no eyewitnesses. And he added that we didn't even have the murder weapon in this case. But ladies and gentlemen of the jury, far more often than not in a murder case, the murder weapon is never found. Yet routinely in those cases, convictions are secured. And as far as eyewitnesses are concerned, common sense is going to tell you that there's rarely going to be eyewitnesses to a premeditated murder. Someone who premeditates a murder doesn't go down to Pershing Square here in L.A. and get on a orange crate with a megaphone, announce his intentions to the world. In a premeditated murder, as opposed to one committed on the spur of the moment, the killer obviously takes steps to help ensure that no one sees him commit the murders. That's why most premeditated murders, like this one, are committed in the darkness of night. If, as Mr. Cochran suggested to you folks, the prosecution had to have eyewitnesses and a murder weapon to get a conviction, in effect, we'd be telling prospective killers, make sure no one watches you, make sure no one is watching, number one, and number two, dispose of the murder weapon, and you're home free. But it's not quite that easy, ladies and gentlemen of the jury. And when you folks come back into this courtroom, you're going to be telling this defendant, by your verdict, it's not quite that easy. In response to the implication of the defense, in this case that circumstantial evidence as opposed to direct evidence is weak, I want to make a few observations. Yes, this is a case of circumstantial evidence. But Judge Ito will give you the following instruction. Quote, both direct evidence and circumstantial evidence are acceptable as a means of proof. Neither is entitled to any greater weight than the other. Actually, eyewitness testimony is usually considered to be the only type of direct evidence. Eyewitness testimony can be great evidence, no question about that. But it is notoriously problematic. For instance, all the cases of mistaken identity. Also, how long did the witness get a good look at the perpetrator? Was it just a second or two? And was it a direct frontal view or merely a side oblique view? How far away was the witness from the perpetrator? Were there any obstructions to his vision? Was the lighting good or bad? Does the witness have good vision? As you can see, there's all types of problems with direct evidence. contrary to popular belief, usually the very strongest evidence in a criminal trial, physical, scientific evidence, like we have in this case, is circumstantial evidence. Examples, fingerprints, and blood, hair, semen, and bullet matchups. There's many other types of circumstantial evidence. Flight, false statements, even a confession. Someone says, I did it. Believe it or not, is usually considered to be circumstantial evidence. Perhaps the power and strength of circumstantial evidence can be explained to you folks by pointing out that it is like a rope, and each fact is a strand of that rope. And as the prosecution in this case piled one fact upon another against this defendant, we added strands and we added strength to that rope. If one strand breaks, and I'm not conceding for a moment that any strand is broken in this case because it hasn't, but if one strand does break, the rope isn't broken. The strength of the rope is barely diminished. Why? Because there are so many other strands of almost steel-like strength that the rope is still more than strong enough to bind this defendant, Mr. Simpson, to justice. That's what circumstantial evidence is all about. As far as the circumstantial evidence instruction Judge Ito will give you, which both Mr. Scheck and Mr. Cochran told you supports a not guilty verdict in this case, that you cannot convict this defendant, quote, unless the proved circumstances are not only consistent with the theory of guilt, but cannot be reconciled with any other rational conclusion, unquote. Would another rational conclusion be that the Himalayan mountain of evidence against the defendant in this case points towards his innocence? Would that be another rational conclusion? I mean, arguing that the evidence in this case, the defendant's blood being found at the murder scene, the victim's blood inside his car and home, the suicide note, running away with the gun, the passport, and the disguise, etc., arguing that all of this evidence doesn't prove guilt beyond a reasonable doubt is bad enough. But to take it to the next level and argue that another rational interpretation of all of this extremely incriminating evidence, like the defendant's blood being found at the murder scene, is that it points to Mr. Simpson's innocence, is simply silly beyond belief. I mean, if your blood being found at the murder scene and running away with a gun, a passport, and a disguise can just as easily be reconciled with a conclusion of innocence as that of guilt, then we're just turning logic completely on its head. And we're living in in apparently a topsy-turvy world, like the one that Ellis saw on the other side of the looking glass. A world where, for instance, an angry person is apt to say, if you don't shut up, I'm going to hit your fist with my nose. The reality is that that circumstantial evidence instruction, which the defense is relying on, is actually a pro-prosecution instruction in this case. Because all of the evidence in this case points towards Mr. Simpson's guilt. None of it can be reconciled with a conclusion of innocence. The defense attorneys in this case, ladies and gentlemen of the jury, in their effort to convince you that you should let Mr. Simpson walk out of this courtroom a free man, have even gone beyond making one outrageous factual allegation after another, such as that the LAPD framed Mr. Simpson. Remarkably, in their closing argument to you, they actually tried to deceive you folks right in front of Judge Ito as to what the law of this case is. Both Mr. Cochran and Mr. Scheck, particularly Mr. Scheck, tried to convince you folks that the prosecution's alleged failure to prove every single point in this case, every contested fact, not only negates all that has been proven, but constitutes a reasonable doubt that entitles their client to a not guilty verdict. Recall, for instance, Mr. Scheck telling you that the LAPD crime lab was a, quote, cesspool of contamination, and therefore this gives rise, he said, to a reasonable doubt in this case. He also told you that since the blood of Mr. Simpson wasn't found on the top of the fingers of the glove found at Rockingham, where he says the blood should have been found if Mr. Simpson had worn that glove, quote, that has to give you a reasonable doubt. He even went so far as to tell you that the prosecution had to prove a negative. He said we had to, quote, prove beyond a reasonable doubt that the blood evidence wasn't tampered with, unquote. But ladies and gentlemen of the jury, that's just not simply the law. Since Mr. Cochran and Mr. Scheck in their summations didn't even dispute the fact, how could they, that whoever killed Ron and Nicole did so with malice aforethought, that is a specific intent to kill, and that intent was a deliberate and a premeditated one. There's only one thing, and one thing only, that the prosecution has to prove in this case, Mr. Simpson's guilt, that he is the one who committed these murders. If we've done that, as we unquestionably have, you folks could have a doubt about 1,000 other things in this case, and you would still, under the law, be duty-bound to come back into this courtroom with a verdict of guilty. If you need further proof that Mr. Scheck was 100% wrong in what he told you, listen carefully to what Judge Ito tells you when he gives you this instruction. These will be his exact words to you, quote, "The prosecution has the burden of proving the defendant guilty beyond a reasonable doubt," unquote. That's what our only burden is, to prove this defendant guilty beyond a reasonable doubt. He certainly won't say anything about our having to prove beyond a reasonable doubt that the LAPD crime lab was not a cesspool of contamination, or having to prove any other contested fact in this case. Obviously, if the prosecution had the burden of proving beyond a reasonable doubt the truth or falsity, as the case may be, of every single point and every contested fact in a case, we'd never get a conviction. I personally find it rather mind-boggling that these two defense attorneys, right in front of Judge Ito, would deliberately attempt to mislead you folks on what the law of this case is, on a legal matter that not just goes to the heart of this case, but to the heart of every criminal case that's ever been tried in this country. I'm referring, of course, to the doctrine of reasonable doubt. Before I attempt to define it for you, I want to discuss one word in that doctrine that's misleading to lay people, the word beyond, in the term beyond a reasonable doubt. As lay people, it could be understandable for some of you folks to think that to prove guilt beyond a reasonable doubt requires, as some defense attorneys suggest when they say beyond a reasonable doubt, that the prosecution has to go beyond the horizon and to the ends of the earth to prove guilt. But actually, in the term beyond a reasonable doubt, the word beyond is a needless appendage that isn't even used in its conventional primary sense of further, more than. If it were, we'd have to prove that there was more than a reasonable doubt of guilt, when obviously we have to prove just the opposite, that there is less than a reasonable doubt of guilt. Instead, beyond is used here in its secondary sense of to the exclusion of. So when I use the term beyond a reasonable doubt hereafter in my summation, you should take that to mean that I'm really saying to the exclusion of all reasonable doubt. The prosecution in this case then has the burden of proving Mr. Simpson's guilt to the exclusion of all reasonable doubt. With this in mind, we can completely eliminate the misleading and confusing word beyond from the term beyond a reasonable doubt and come up with this. If you do not have a reasonable doubt of Mr. Simpson's guilt, convict. If you do have a reasonable doubt, acquit. We have eliminated the word beyond from the term beyond a reasonable doubt, and we still have a very accurate statement of the doctrine of reasonable doubt. What is a reasonable doubt? As Judge Ito will tell you, it's not a mere possible doubt. What is it then? It's a sound, sensible, logical doubt based on the evidence that came from that witness stand. And I'm confident you folks agree with me that there is no sound, sensible, logical doubt of this man's guilt. In fact, there's no doubt at all. Mr. Cochran, in his summation, referred to Detectives Van Adder and Furman as the, quote, twins of deception. Remember that? He called Detectives Furman and Van Adder the twins of deception. And he argued that the book of Luke in the Bible says that if a man tells a lie, You can't believe anything else he says. But let's take Detective Furman, for instance. Whether or not he used that racial slur years ago, years prior to these murders, obviously has no connection at all to the facts of this case. So his lie is just a personal matter that is unrelated to the facts of this case. But Mr. Simpson, Mr. Cochran's own client, on the night of these murders, tells an enormous, blatant lie to Ellen Park, the limo driver, that I overslept, just got out of the shower, and I'll be right down, when Mr. Park had just seen him enter his home a couple seconds earlier. A lie he would have had no reason to tell if he hadn't just committed these murders. And Mr. Cochran has the guts to argue the book of Luke to you folks? The contention of Mr. Cochran that the socks of Mr. Simpson's found at the foot of his bed were planted is groundless, and I'm very confident that I can demonstrate to you why. Yes, LAPD photographer Willie Ford did testify that when he videotaped Mr. Simpson's bedroom on the day after the murders, June 13th, 1994, the timer on his video machine said 4:13 p.m. Yet Dennis Fung told you folks that he picked those socks up at 4:30 p.m. And from this, Mr. Cochran argues to you that those socks must have been planted in that bedroom after Willie Ford videotaped the room and left the room. But it's clear that either Mr. Fung was wrong about the time, which couldn't possibly be more common for human beings, or the timer on Mr. Ford's video machine, which he acknowledged had not been checked and reset for over 2 years, was off. I say that because although there's this discrepancy between Ford's and Fung's testimony, one thing Fung and Ford did agree on, Mr. Cochran conveniently neglected to mention it to you, both Ford and Fung testified that Fung had told Ford not to videotape that room until after he, Fung, had collected all of the evidence from the room, which certainly would have included the socks. And Ford testified that he followed Fung's instructions. So although we can't know for sure what time Ford videotaped the room, we do know that it was after Fung removed the socks from that bedroom. And this is why, of course, Ford never saw the socks there at 4:13 p.m. or whatever time it was when he videotaped that room. The socks weren't there anymore. Fung had already picked them up. The conclusive proof that the socks were implanted by evil LAPD conspirators after Ford videotaped the room is the testimony of LAPD Sergeant Adalberto Luper, one of Mr. Cochran's own witnesses. I mean, isn't this man familiar with the testimony of witnesses he himself calls to the witness stand? Luper, who is black, testified that he saw the socks at the foot of Mr. Simpson's bed at 12:30 p.m. that day, long before Ford videotaped the room, proving that they were there before he videotaped the room, that they were not put there after he videotaped the room. Mr. Cochran also argued, as you know, that when the defense experts, Drs. Bodden and Wolf, saw the socks, along with all the other evidence in this case, on June 22nd, 9 days later, they never saw any blood on the socks. And from that, Mr. Cochran has argued that the LAPD conspirators must have planted blood on those socks at some later time, sometime after June 22nd, 1994. But the obvious reason that Drs. Bodden and Wolf did not see the blood on those socks, I think I'll be able to demonstrate it to you, is that these were very dark socks. Even the LAPD didn't see the blood on those socks, didn't discover the blood on the socks until much later, August the 4th, when the socks were subjected to their first chemical examination. So even the LAPD didn't discover it until long after June 22nd. And it's understandable why Doctors Baden and Wolf did not see the blood on the socks on June 22nd. In fact, as you recall, another defense expert, Dr. Herbert McDonald, this is a defense witness now, admitted on cross-examination that it would take, quote, good high-intensity illumination, unquote, to see the blood on the socks. And he added, as you know, that even the pretty good lighting, he said, in this courtroom, even under this lighting, he said it would be difficult to see the blood on those socks because they were so dark. But you know, this whole allegation of the LAPD planting the socks in Mr. Simpson's bedroom is ridiculous on its face, and it illustrates that when you make phony allegations like this, you end up eventually sounding foolish. In one breath, Mr. Cochran says the LAPD conspirators planted the socks at the foot of Mr. Simpson's bed on June 13, 1994. In one breath. But then he goes on to tell you that there was no blood on the socks when Doctors Baden and Wolf examined the socks 9 days later. But if we buy Mr. Cochran's version of events, why would the police have planted the socks there in Mr. Simpson's bedroom without any blood on them in the first place? Does Mr. Cochran really expect us to believe that these evil LAPD conspirators were brilliant enough to pull off this incredibly involved, complex conspiracy, this frame-up, without a hitch, but so remarkably feeble-minded and cloddish that when they planted the socks at the foot of Mr. Simpson's bed, they forgot to put the blood on them. Forgot to put the blood on them. And then a month or so later they said, hey, we forgot to put the blood on the socks. And then got the socks out of the property division of the LAPD, rounded up some blood of Mr. Simpson's and Nicole's, and at that time put the blood on the socks. Is there any limit? Are there any boundaries to the silliness of the defense in this case? Can their silliness even be seen from Mount Palomar? Can the frontiers of their silliness even be seen from Mount Palomar? I don't know. Or maybe this is the answer. Maybe this is the answer. Mr. Cochran might have a point after all. He didn't argue this to you, but maybe the answer is that when these evil LAPD conspirators planted those socks at the foot of Mr. Simpson's bed, they weren't trying to frame him with the socks. They just wanted people to think that Mr. Simpson wasn't neat, you know, that he wasn't tidy, that he didn't even bother to put his used socks away somewhere in a hamper. They weren't trying to frame him. They didn't want him to look neat. And later, a month or two later, for the first time, they decided to put some blood on those socks. Again, it's almost embarrassing for me to have to respond to defense arguments like this. With respect to Detective Van Adder not immediately booking the vial of Mr. Simpson's blood when he got it on the afternoon following the murders, and instead bringing it back to Rockingham and turning it over to the criminalist, Dennis Fung, obviously with 20/20 vision, that was not a very wise thing for him to do. Why would he do it then? I think the answer is obvious. How could Van Adder in his wildest dreams ever imagine that there were actually lawyers like Johnny Cochran and Barry Scheck around who would say that the reason he brought that vial of blood back to Rockingham was to take blood out of it and sprinkle and plant it in an effort to frame Mr. Simpson? When you have an innocent state of mind, thoughts like that just don't enter your mind, particularly when you've been on the force for 26 years and have investigated thousands of cases, and not once in all those 26 years has anyone ever accused you of such a vile, despicable deed. Yes, he testified. He and his partner, Tom Lang, could have booked the vial immediately. But the reason they didn't is they didn't have a DR number, the divisional record number assigned to each case under which all items of evidence are booked. Could they have gotten the DR number? Yes. But he informed us that the DR number is nearly always gotten after all the evidence is collected from the crime scene by the criminalist pursuant to the search warrant. And at the time he came into possession of that vial of blood at 3 p.m., June 13th, 1994, Dennis Fung, the criminalist, was still at the crime scenes of Bundy and Rockingham collecting evidence. Since each piece of evidence is sequentially assigned a property item number, Van Adder said that the problem he would have had in getting a DR number and booking that vial of blood under that DR number, it would have been item number 1 if he had booked it under that DR number. The problem is that he didn't know what item numbers Fung had already assigned to pieces of evidence that he had collected at Bundy and Rockingham. As Fung testified, quote, "If Van Adder had booked the vial of blood as item number 1, it would have messed up all my numbers because I had already assigned number 1 to the blood stain I found on the outside of the Bronco above the driver's door handle," unquote. So to avoid the problem, Van Adder brings the vial of blood back to Rockingham, turns it over to Fung for Fung to book along with all the other evidence. And both Lang and Van Adder testified, by the way, that when detectives physically turn over evidence to the criminalist in the case, in their mind, they consider this the equivalent of booking it. This defense charge that Van Adder planted blood from Mr. Simpson's reference vial at Rockingham, like all the other defense allegations in this case, is preposterous, and again, I'm confident I can demonstrate why to you. Stop to think about it for a moment. You saw TV film footage of Van Adder arriving at Rockingham at 5:16 p.m. carrying this large envelope, which he said contained the vial of Mr. Simpson's blood. Now, if it had been Van Adder's intent to bring that vial of blood back to Rockingham to plant blood from it, why wouldn't he have concealed that small vial of blood in his suit coat or the pockets of his pants? Why carry it there in a large envelope, thereby advertising to everyone that he was bringing something onto the premises? That doesn't make any sense at all. You also saw a police video showing Fung at 5:20 p.m. in the foyer of the Simpson residence holding that same envelope. Fung testified that he received the envelope from Van Adder, saw the vial of Simpson's blood inside, then wrote on the envelope, a prosecution exhibit, quote, "Received from Van Adder on 6/13/94 at 17:20 hours, that is 5:20 p.m. So to believe the planting of blood argument, we'd also necessarily have to believe that Dennis Fung, the obviously decent, sincere young man, not even a police officer, just an employee at the LAPD, was one of the main conspirators who framed O.J. Simpson. That either Fung himself planted all the blood, or that after he got the vial from Van Adder, he surreptitiously returned the vial to Van Adder and then committed perjury on the witness stand here when he told you folks that after he got the vial of blood, he kept it in his possession until he booked it. That's really believable, isn't it? In addition, how could Van Adder even fantasize, how could he even dream that he'd be able to bring that vial of blood back to Rockingham and plant blood from it when he had been to Rockingham earlier in the day and he knew that hundreds upon hundreds of reporters and members of the media had already congregated at Rockingham, their cameras blanketing the premises, picking up for the evening news, the movements of everyone on the estate. There were helicopters up above, filming everything down below. Just a wonderful, marvelous environment for Van Adder to go around sprinkling Mr. Simpson's blood. And he couldn't even do it in the evening, since a sizable contingent of the media remained throughout the evening and night, that is, around the clock at Rockingham. And why, indeed, would Van Adder even feel there was any need to plant blood of Mr. Simpson's at Rockingham when just a couple hours earlier, Mr. Simpson had already admitted to him and his partner Tom Lang that he had dripped blood all over his car, home, and driveway. Why would he think there was any need to plant more blood at Rockingham than Mr. Simpson admits was already there? Need I say any more? The allegation by Mr. Cochran and Mr. Scheck that Detective Van Adder, here's a guy 26 years on the force, not one citizen complained against him in 26 years, and these people are accusing him of bringing that vile blood back to Rockingham, taking blood out of it, and sprinkling it around in various places to incriminate the defendant. That allegation is more than outrageous, ladies and gentlemen. It's absolutely obscene. I know they're not, but they should be ashamed of themselves. With respect to Dr. Henry Lee, whom Mr. Cochran and Mr. Scheck touted so much to you in their summations, how could this man come before you folks posing as the leading forensic scientist in this country and suggest to you the possibility that a shoe print made in concrete years ago, which he personally saw and photographed, could be the shoe print belonging to a killer other than the defendant in this case? How dare this man not tell you that that shoe print was a permanent indentation in the concrete, whose ridges and grooves you could feel with your fingers? How dare he not tell you that? How dare this man, who should have been ridden out of town on a rail, try to do this to you folks? If we hadn't had Agent Bodziak of the FBI go back to that walkway at Bundy and look at, physically touch, and photograph for you that permanent indentation in the concrete, we would have never known that Dr. Lee's testimony was 100% wrong. Pardon the pun, but we have concrete evidence that there's something wrong, terribly, terribly wrong with Dr. Lee to give you folks testimony like that. I think I demonstrated to you how the defense's garbage in, garbage out theory on contamination was itself garbage, that it was totally lacking in merit. So in Mr. Scheck's argument to you, although he didn't jettison completely the contamination argument, he focused in much more on an equally absurd theory, to wit, cross-contamination. Under the law, a jury verdict must be based, as you folks know, on the evidence, not on conjecture, that is speculation, or possibilities. But in Mr. Scheck's world, conjecture and the possibility of cross-contamination, even though he doesn't have a speck of evidence to support it, is the equivalent of proof that it did happen. But if Scheck doesn't have a speck, ladies and gentlemen, if Scheck doesn't have a speck, you must reject his argument on cross-contamination. With respect to conjecture, Judge Ito will give you the following instruction. You must not be influenced by conjecture. With respect to possibilities, he will instruct you, quote, a reasonable doubt is not a mere possible doubt, because everything relating to human affairs is open to some possible or imaginary doubt. Before we analyze what Mr. Scheck perceives to be the speck of evidence, the tantalizing possibility that is the crown jewel in his tiara of nonsense about cross-contamination, let's take this issue from the top. As you know, ladies and gentlemen of the jury, these defense attorneys have alleged that blood on the rear gate at Bundy was planted by these evil LAPD conspirators. They've alleged that the glove at Rockingham was planted. They allege that blood in Mr. Simpson's Bronco was planted. That blood on Mr. Simpson's socks in his bedroom was planted. But even these defense attorneys, and I underline and I italicize the word even these defense attorneys who we've seen at this trial have elevated audacity to symphonic and operatic levels, even they didn't have the guts to allege that the 5 blood drops at the murder scene, conclusively determined by DNA tests to be Mr. Simpson's, 4 of which out of the 5 were immediately to the left of the killer's bloody shoe prints leaving the crime scene. Even they didn't have the guts to allege that those 5 blood drops were planted by the LAPD in this case. As you recall, their argument to you was that those 5 blood drops belonged not to Mr. Simpson, but to the true killer. And because they had been exposed to bacteria, the elements, dirt, etc., they lost all their DNA, which the experts have told you from the witness stand would have been an absolute impossibility in such a short period of time. And later on, when those 5 blood drops on cotton swatches were at the LAPD crime lab, which Mr. Scheck says is a cesspool of contamination, maybe those 5 blood drops became cross-contaminated with blood from Mr. Simpson's reference vial. And that's why the DNA test showed that it was Mr. Simpson's blood at the murder scene. How specifically, per Mr. Scheck, could the cross-contamination have taken place in this case? He relies on the so-called Colin Yamauchi incident. As you recall, Colin Yamauchi, one of the LAPD's criminalists, testified on cross-examination by Mr. Scheck that in opening up the vial of Mr. Simpson's reference blood at the crime lab on June 14, 1994, he got a, quote, tiny dot, unquote, of the blood, about 1/8 of an inch in diameter, on the latex glove of his left hand. He said this was a common experience when you take the rubber cap off the vial. But Yamauchi testified that he immediately discarded both his left and right latex gloves in a nearby receptacle and put on a new pair of gloves, which he said is just routine, automatic behavior for criminalists in this type of situation. Moreover, he testified that at the time of this incident, the cotton swatches containing the 5 blood drops were on top of a table 10 to 15 feet away and were enclosed within paper bindles, which were themselves enclosed within coin envelopes. From this totally innocuous and innocent incident, Mr. Scheck, who was possessed of a rather fertile, pregnant imagination, argued to you folks that there was a, quote, spillage of blood. A spillage of blood. This tiny dot became a spillage of blood, adding that he had no reason to believe Mr. Yamauchi when Yamauchi testified that he changed his gloves. And Mr. Scheck goes on to say that as a result of all this, quote, there could have been cross-contamination. I have to take off my jacket. Is it be okay if I take it off? I'm not going to take off my vest, by the way. It's kind of a security blanket. I've been masquerading as a lawyer, so I've got to keep your vest on. Note that there wouldn't have been any way, there would not have been any way for Mr. Scheck to even know about this tiny dot of blood getting on Yamauchi's glove if Yamauchi hadn't been honest enough to tell Mr. Scheck. But Mr. Scheck, who wouldn't trust the Pope, tells you folks that he has no reason to believe that Yamauchi's telling the truth when he testified on that witness stand that he changed his gloves. Since the only evidence in the record is that Mr. Yamauchi did change his gloves, Scheck doesn't have a speck of evidence to support his theory of cross-contamination. All he can say is that cross-contamination could have taken place. And I say could have, should have. If I had wings, maybe I could fly. You make desperate, foundationless arguments like this, ladies and gentlemen of the jury, when your client is not only dripping with guilt, but dripping with blood, and there's nothing else for you to argue. Quite apart from Mr. Yamauchi changing his gloves, the conclusive evidence, the positive evidence that there was no cross-contamination in this case is that if there had been, those 5 blood drops would have had EDTA in them. We learned at this trial that EDTA was a preservative an anticoagulant that's added to all reference blood. So Mr. Simpson's reference blood had EDTA in it. The defense in this case alleged, they didn't prove it all, but they alleged that there was a residue of EDTA on the blood on the rear gate. They alleged that there was a residue of EDTA on the socks in Mr. Simpson's bedroom. But they did not allege, if you recall, they did not allege that there was any EDTA in those 5 blood drops found at the murder scene. And if there had been cross-contamination, automatically there would have had to have been EDTA in those 5 blood drops. Since those 5 blood drops did not have EDTA in them, this is not only conclusive proof that there was no cross-contamination in this case, it is also conclusive proof that those 5 blood drops had to have come from this man's body at the time of these murders, most likely from the cut, the deep cut to the knuckle of his left middle finger. There's simply no other way that his blood could have gotten at that murder scene. An additional reason why we know there was no cross-contamination here is that if there had been, the DNA content on those 5 blood drops would have been a lot higher than they were, because the reference blood hadn't been exposed to the elements. You recall that those 5 blood drops, because they had been exposed to the elements, had degraded somewhat. And the DNA content on 4 out of the 5 of them wasn't sufficiently high for them to conduct an RFLP test. They had to conduct a PCR test. As you know, only with respect to the 5th blood drop were they able to conduct an RFLP test. Since we know, we don't think, since we know that there was no cross-contamination in this case because of the absence of EDTA and the low DNA content on those 5 blood drops, there's only one catch-all fallback argument for the defense to make in this case with respect to those 5 blood drops. And that's their pet argument that this blood had been contaminated by bacteria, dirt, the elements, making all the DNA tests conducted on them, quote, unreliable. Their garbage in, garbage out argument. But we know that even if there had been contamination, in this case, it could not convert someone else's blood into Mr. Simpson's blood. I mean, to believe this ridiculous contamination argument, you'd have to believe that this blood found at the murder scene, which has been identified as Mr. Simpson's, actually belonged to Mr. X, the true killer. And during this trial, Mr. X, the true killer, somewhere else. Maybe he's in a motel room in Amarillo, Topeka, Boise, Idaho, watching these proceedings on television. And because of contamination caused by dirt, bacteria, or what have you, out of the 5.5 billion people on the face of this earth, X's blood miraculously was transformed to O.J. Simpson's blood. And not just once, mind you. Apparently, because of contamination, all 5 separate drops of Mr. X's blood were magically transformed to Mr. Simpson's blood. Out of 5.5 billion people on the face of this earth. Right. And Mother Teresa used to play fullback for the Chicago Bears. And my name is Mahatma Gandhi. And Frenchmen don't drink wine. Is there any end at all to the insanity heaped upon us by these defense attorneys in this case? I mean, they're merciless, sadistic. Shouldn't common decency tell them that they should at least provide us with special clothing to protect us from this radioactive nonsense of theirs? even though it couldn't be more obvious that there was no police conspiracy to frame the defendant in this case, folks, both Mr. Cochran and Mr. Scheck, in their summations to you, clung tenaciously to this theory because they have nothing else to argue to you. And since they are continuing to argue this nonsense, I must continue to expose this conspiracy argument for the nonsense that it is. With respect to you black folks on the jury, Mr. Cochran cleverly argued to you the police frame-up theory from your experience of police brutality. Two completely different types of police misconduct. I'm sure he was hoping that it would sail right over my head without my even feeling the breeze, but I'm here to inform Mr. Cochran that it did not. You black folks know about police brutality, even if you haven't experienced it personally. You know it through your friends, your relatives. But even though I'm white, I'm also aware, I'm well aware, that there's a small strain of law enforcement officers here in Los Angeles and in other major cities of this country who've been manhandling, mistreating, and in some instances brutalizing members of your community and getting by with it. They are a small percentage of the force who stain the blue uniform of the majority of the force who don't do those things. So I'm aware that police brutality and lies by the police to cover it up is common. Not percentage-wise, but numerically speaking. But if I may be so presumptuous, and in all deference to you black folks on the jury, this, what I've just been talking about, this is the type of police misconduct that the black community has experienced throughout the years, not police frame-ups. I would ask you black people in the jury to ask yourself this question back in the jury room. Has it ever happened to any relative of yours or close friend or anyone you know that they were framed by the police for a burglary, a robbery, a murder, an arson? Statistics show that this type of thing is virtually unheard of. Now, I'm not talking about the 1930s in the Deep South. I'm talking about the last half century right here in Los Angeles. Not just statistics, but the nature of civil lawsuits by blacks against the police here in Los Angeles clearly and unequivocally show this. Civil lawsuits by blacks against the LAPD and the LA Sheriff's Department for police brutality, common. We read about it all the time in the newspapers. Whereas suits by blacks against the police for being framed, virtually non-existent. Has it ever happened? Of course it has. As it is said in the book of Ecclesiastes, the Old Testament, years before the birth of Jesus, there's nothing new under the sun. But it's extremely rare. And when it does happen, almost invariably, it's in simple, uncomplicated drug cases. And as I said earlier, if the police ever were going to frame a black man, this defendant, Mr. Simpson, would be one of the very last black men on the face of this earth whom they would even dream of framing. So Mr. Cochran, and I have to give him credit for this, because it was quite artfully deceptive on his part, was hoping that you black folks back in the jury room would buy his frame-up theory by saying to yourself, this is the LAPD, and we know we can't trust them. Well, maybe, as I said, you can't trust a certain small segment of the LAPD for police brutality and then lying to cover it up. But frame-ups? Frame-ups? No way, Jose. No way. Again, although I'm not saying it has never happened, it's common knowledge that it very definitely is not a part of the normal history of the LAPD and the black community here in Los Angeles. That is not an opinion. That's a fact. Let me tie in what I've just told you about the police not framing blacks to Mark Fuhrman in this case. But first, let me go back just a little bit. The defense in this case, at one time or another, has suggested to you folks that just about everyone involved in the investigation of this case was either involved in the conspiracy to frame Mr. Simpson or the conspiracy to cover up the frame-up. In fact, with respect to the latter, Mr. Cochran specifically told you in his summation that in his opinion, Willie Ford, the black police photographer, was the only one on this case who, quote, wasn't a part of the cover-up, unquote. So the defense attorneys are not just accusing the 4 detectives in this case, but their colleagues, from Officer Spangler, Risky, all the way up to Commander Bushy. Even the police criminalist Dennis Fung. In fact, even Fung's young assistant, Andrea Mazzola, who told you folks that prior to this case she had never even heard of O.J. Simpson. Didn't even know who he was. She may not have known who he was, but it certainly sounded like a good idea to frame him. And that's one of the reasons why she wanted to work for the LAPD. They told her about all the fringe benefits. 3 weeks paid vacation, free medical care, get to frame all the people you want. Well, that's how silly this is. This whole thing is silly, and I'm just trying to illustrate how silly it is. The defense even claimed that Thano Paradas, the male nurse who withdrew Mr. Simpson's blood, was a part of the conspiracy. Remember, they suggested that he changed his testimony to account for the 1.5 cc's of blood from Mr. Simpson's reference vial that they claim was missing. I mean, everyone was involved. I can just picture Phil Van Adder on the telephone on the night of the murders, calling his colleagues, "Hey, Sam, we got a great conspiracy going on down here. We're framing that black dude, O.J. Simpson." "For Christ's sake, Phil, do you know what time it is? It's 3 in the morning. I know, but how often do you get an opportunity to nail someone like Simpson?" "Yeah, I guess you're right, old buddy. Let me take a quick shower. I'll be right down." "Well, you better get your rear end down here right quick, because they're not going to wait for you all night." "Okay, Phil, okay." It reminds me of the film JFK. I don't know if any of you folks saw that film a couple years ago about the assassination of John F. Kennedy. At one time or another in that film, it's quite a long film, but at one time or another in that film, the director, Oliver Stone, unbelievably, had the CIA involved in the conspiracy to kill the president, the FBI, Secret Service, Russian KGB, the mob, military-industrial complex, Vice President Lyndon Johnson, Dallas Police Department, Castro, anti-Castro Cuban exiles. They're all involved in the conspiracy to kill President Kennedy. I mean, where did all these people gather to form this elaborate conspiracy? Madison Square Garden? As I was walking out of the movie, I remember thinking to myself that I was apparently one of the few people who was not involved in this conspiracy. If we're to believe Mr. Stone, no one wanted poor President Kennedy to live. I mean, not even bitter enemies like the KGB and the CIA. They got together on this one. Couldn't get together on anything else, but they got together on this one. Anyway, getting back to this case, although everyone and his grandmother was apparently involved in the conspiracy to frame Mr. Simpson, according to the defense, the main conspirator, the head guy, the Maharaja of this dirty, rotten plot to frame this man is Mark Fuhrman, the supreme racist, the devil incarnate. You recall that Kathleen Bell testified that when she met Fuhrman somewhere between 1985 and 1986 at the Marine Recruiting Office, he told her that whenever he'd see a black man in a car with a white woman, he'd pull them over. And Miss Bell said, "Well, what if they haven't done anything wrong?" And he responded that he would, quote, "find something." And so Mr. Cochran argued to you, quote, "This man will lie to set you up," referring to black people. That is what he is saying there. He would do anything to set you up because of the hatred he has in his heart, unquote. Well, number one, Miss Bell didn't say that Furman told her that he would frame the black man and his white woman friend for any crime, did she? No, only that he would come up with some excuse, valid or invalid, to pull them over. Probably wanted to hassle them. But again, that was 10 years ago, when Furman apparently had racist tendencies. But as I pointed out in my opening argument, Furman clearly seems to have shed those racist tendencies in recent years. The defense, of course, doesn't agree. The essence of what Mr. Cochran told you, and the essence of the defense in this case, is that Mark Furman framed O.J. Simpson because Simpson is black, Furman's a racist, and that's what Furman does. He frames black people. But wait a while, folks. Wait a while. Let's stop and think about this terrible, vile charge for a moment. Mark Furman has been a Los Angeles police officer for close to 20 years. He testified that during that time, he arrested hundreds upon hundreds of black people. Over 2,000, he said. Now, I think most of you folks will agree that if there's one thing that's even worse than police brutality, it's being framed for a serious crime that you did not commit. A bloody nose, a broken arm can heal. But going to the state prison for 5 to 10 years and being branded a felon for the rest of your life, I think you'll agree, is a lot worse. Now, don't you think that if this fellow Furman were the type who liked to frame black people, that there would have been a considerable number of black people framed by him throughout the years? And that you would have heard from most, or at least some of them, during this trial? I mean, if you're a black man framed by Furman, let's say for a burglary, you serve 5 years at San Quentin, and you get out, and Furman's in the news, don't you automatically call Johnny Cochran or another member of the defense team and say, hey, this guy framed me? Not just to get even with him, which would be your primary motivation, but in a big case like this, you'd be a hero to many in the black community. You could sell your story for a lot of money. I repeat, if Furman had been the framing cop the defense wants you to believe he is, why wasn't there a parade of black people taking this witness stand at this trial to tell you folks that they were framed by Mark Furman? After close to 20 years on the force, the only black man that the defense called to this witness stand to testify against Mark Furman was Roderick Hodge. Hodge, as you recall, had had a run-in with Furman years earlier. And when Furman later arrested him on a drug charge in 1987, 8 years ago, Furman had a partner at the time and arrested Hodge. Hodge said that he mistreated him and said to him, I told you I'd get you, nigger. But he didn't say anything about Furman framing him or setting him up or planting evidence or falsely accusing him of any crime. Not one word. Not one word from Roderick Hodge. Didn't say anything about framing him. As far as testimony at this trial, coming from this witness stand, under oath, that any black person was ever framed by Mark Furman, or for that matter, any other member of the LAPD involved in the investigation of this case. As you know, this witness stand was silent. Silent. As quiet as a church mouse. As quiet as a statue. As quiet as those pictures up there on the wall in front of you. Even though Mark Furman arrested over 2,000 black people in his career, not one black person took this witness stand and told you folks that he or she was framed by Mark Furman. And the reason no black person so testified is no such black person exists. It's nonsense. It's moonshine. To the complete contrary. We learned at this trial that Mark Furman was out there working hard to free a black man charged with the murder of a white man. You folks should not only be insulted that these defense attorneys try to deceive you like this. You should be angry at them. How dare they think so little of your intelligence to try to sell you a preposterous story like that. A story that children in sand piles wouldn't believe. After my opening argument to you folks about how silly and preposterous the police frame-up theory was, as you know, Mr. Cochran, in his closing argument, tried to beef up his police conspiracy theory to you. He came up with a second reason for why the police would want to frame O.J. Simpson. It's in addition to the main argument that he's used throughout this whole trial, that these were just racist cops out to frame a black man. And this new argument he came up with was a real beaut. This is what he told you, you recall, in answer to his own question. Why would all these police officers set up O.J. Simpson? They believed he was guilty, and they didn't want to lose another big case, unquote. Unbelievable! Johnny Cochran has come up with a new twist. Everyone knows that the word frame means to set up an innocent person. My Random House Dictionary defines the word frame as, quote, incriminating an innocent person through the use of false evidence. But according to Mr. Cochran, the LAPD thought they were framing a guilty man. And they framed him, he says, because they didn't want to lose another big case. But if Mr. Cochran is going to make an outrageous allegation like this, don't you think he should have at least told you folks what other big cases the LAPD has been losing recently or within the past several years? He didn't tell you. Is he talking about the Menendez case? The problem with that wasn't an LAPD case. That was a Beverly Hills Police Department case. Beverly Hills Police Department. And incidentally, as you know, that case was a hung jury. It's going to be retried, so it's still very much alive. But that was a Beverly Hills Police Department case, not an LAPD case. Is he talking about the Damian Williams case that arose out of the Los Angeles riots? Let Mr. Cochran tell Damian Williams that. Let him tell Damian Williams that the LAPD lost that case. Damian Williams was convicted of mayhem and is now serving a 10-year sentence in the state prison. Is he talking about the Rodney King case? You mean all the officers who Mr. Cochran claims framed Mr. Simpson in this case were upset? Were upset that 4 other LAPD officers were found not guilty in Simi Valley? That they were upset about that? But if that's true, Mr. Cochran is talking out of both sides of his mouth. Because if they were upset that the 4 members of the LAPD who were charged with beating Rodney King were found not guilty, then they're pretty good people, right? Certainly not the kind who are racist, not the kind who would frame a black man. And if he's going all the way back to the McMartin child molestation case in 1990, that wasn't the LAPD either. That was the Manhattan Beach Police Department. So I want to know, what other big cases was Mr. Cochran talking about? Even though this is my time for argument, I'm going to give Mr. Cochran the opportunity to stand up right now in this courtroom and tell you folks what other big cases he was referring to that the LAPD lost within the last several years that caused all these LAPD officers to risk going to the gas chamber for or state prison just so that the LAPD would not lose another big case. Mr. Cochran, I'm going to give you the amount of time it takes now to stand up and name these other cases. And please, Mr. Cochran, no speeches. All this jury and judge and I and everyone in this courtroom want to know is the name, the identity of these other cases. Mr. Cochran, the floor is yours. As kind of a companion argument to his police frame-up theory, Mr. Cochran also told you folks that because of the LAPD's obsession to win this case, they had, quote, rushed to judgment against Mr. Simpson. ignoring any and all evidence that may have pointed away from Mr. Simpson in the direction of someone else. Mr. Cochran should know that his rush to judgment argument is somewhat redundant to his main argument of a police frame-up. Obviously, if the police, per Mr. Cochran, are framing Mr. Simpson, they're certainly not going to be looking for evidence pointing in the direction of anyone else. But let's ignore the redundant, almost inconsistent nature of Mr. Cochran's argument and look at for a moment his rush to judgment allegation. As you folks know from your everyday experiences, the evidence, I guess in your private life you'd call it the circumstances or the situation, is what leads you in a certain direction. You don't go to the door to open it for someone unless you hear someone knocking at the door or you hear the doorbell ring. If you wake up in the morning and there's a small puddle of water on the kitchen floor, when you call the roof man, you don't tell him to check for a leak on the ceiling of the living room. These things are so obvious that it's silly to even talk about them. But it's just as obvious in a criminal investigation. You follow the trail of evidence. In this case, the trail of blood that led from the murder scene to Mr. Simpson's Ford Bronco, right up to the front door of his home, and then inside. All of the evidence in this case led to one person, and one person only, O.J. Simpson. There was no piece of evidence that led to anyone else. Under those circumstances, what were the police supposed to do? Pretend that evidence existed, pointing in a direction away from him towards someone else? When Detective Lang was asked during the trial by Mr. Cochran if the LAPD had pursued the possibility that someone else may have been responsible for these murders, he responded, quote, "I had absolutely no other evidence that would point me in any other direction. There was nothing to pursue." If Mr. Cochran is going to make the charge he has, don't you think that with all the police reports and all the witness statements that my office has provided him with, as well as all the reports and all the statements that have undoubtedly been given to him by his own defense team's private investigators, that he should have told you? Now, for example, ladies and gentlemen, take this and then give you some fact or circumstance and then say, why didn't the LAPD check that out? But he couldn't refer you to even one fact or circumstance, not one, that pointed in the direction of anyone other than his client being responsible for the murders of Nicole Brown Simpson and Ronald Goldman. Before we move on, I'd like to make one final observation about Mr. Cochran's rush to judgment argument. Even though I don't believe it for a moment, let's assume just for the sake of argument the police did rush to judgment in this case, that they immediately suspected Mr. Simpson and started looking for incriminating evidence against him to the exclusion of everyone else. Let's make that assumption. So what? Whether they rushed to judgment or not, they still found, for instance, Mr. Simpson's blood at the murder scene. Not someone else's. So what's Mr. Cochran's point? Does Mr. Simpson's blood being found at the murder scene cease being his blood simply because there's a rush to judgment in finding it? Does Ron's blood and Nicole's blood and Mr. Simpson's Bronco cease to be their blood simply because there was a rush to judgment in finding it? Again, what's Mr. Cochran's point? In Mr. Cochran's summation to you, you recall he said that Mark Furman should have been booted off the police force a long time ago, and he said that you, the jury, by your verdict, should stop the Mark Furmans of the world and the cover-up for him by others. Then he said, quote, if you, referring to you folks, if you don't stop it, then who? Well, first of all, the defense never offered any evidence at all, not one speck of evidence, just wild speculation. They offered no evidence that Mark Furman planted that bloody glove at Rockingham, nor did anything else wrong in this case for anyone to cover up for. But even if we assume for the sake of argument that he did, the only job that you folks have to do in this case is to determine from the evidence if the prosecution has met its burden of proof of proving this man guilty beyond a reasonable doubt. Your job is not to try to change the police or society by your verdict. No jury in any case has such a duty. Not only don't you have such a duty, but it would be a very definite and serious violation of your oath if you were to let such a perceived duty influence your verdict in this case. So rather than the wholly improper question by Mr. Cochran, if you don't stop it, then who? Let's ask a much more proper question, one that you as jurors should definitely be asking yourselves. To paraphrase Mr. Cochran, if Mr. Simpson didn't commit these murders, then who? We know Mr. Simpson beat his wife severely to the point of the photos you folks saw. Poor Nicole's face, heavily swollen, black and blue. To the point where she had to call the police on Mr. Simpson 9 times during their marriage. To the point where she was in fear of her life at his hands. Once again, recall her crying out to Officer Edwards, "He's going to kill me! He's going to kill me! He's going to kill me!" People, even those who are getting a beating, normally don't use words like that. You only use words like that if you sense that it really might happen. Who else would have had any reason or motive to kill the 2 victims in this case? We know from the evidence that both Ron and Nicole were apparently well-liked, fun-loving young people in the prime of their life. But you know, this is somewhat of a superfluous discussion. Because even if Ron and Nicole each had 100 people whom they knew, who hated them, despised them, bitter enemies, who had a motive to kill them, we know that none of them actually decided to do it. It was Mr. Simpson's blood found at the murder scene, not someone else's. Still addressing ourselves to the who else question, we also know these murders weren't committed by a burglar or a robber, because there was absolutely no evidence that there was any burglary or robbery in this case. These aren't the type of murders that burglars or robbers commit anyway. And it's pretty clear the murders weren't done by a professional hitman. Contract killings, for the most part, there are exceptions, but for the most part, they're done with a gun. They're quick. They're not messy. These murders, ladies and gentlemen of the jury, bear the unmistakable signature of a killer who was intimately involved with at least one of the victims. The vicious knife thrusts were born out of an angry and wild passion, not some impersonal, mechanical intent to get some job done for some third party. I ask you once again to ask yourself this question back in the jury room. If O.J. Simpson, the defendant in this case, didn't kill Ron and Nicole, who else would have had any reason or motive to kill these 2 young people, and particularly in such a brutal, savage way? And one thing we know about the defense in this case, they had all the money they needed to defend this man. One of the witnesses, Dr. Bodden, you heard the testimony, he got paid in excess of $100,000. I don't know about you folks, that's more money than I make in an entire year. Dr. Bodden alone got in excess of $100,000. So we know that money was no object in this defense team's representation of Mr. Simpson. A large staff of lawyers and assistants, private investigators, you name it, they had it. And they had to know, anyone would, that the very best defense to these murders is to prove, or at least offer some evidence, that someone else committed these murders. And you just know that for the past year, they've been scouring every nook and cranny in this city and elsewhere to see if they could put the hat on someone else for these murders. I mean, they even set up an 800 number, begging for any scrap of information pointing in the direction of someone else. We also know the defense had the power of subpoena. And we've seen that they weren't hesitant about calling witnesses to the stand when they were trying to prove a point. Yet consider this. After all these months and all the money expended on this man's defense, undoubtedly in excess of $1 million, they never offered one witness, not one piece of evidence that pointed in the direction of any person other than this man being responsible for these murders. And the reason they didn't is no such witness, no such piece of evidence exists. And ladies and gentlemen of the jury, I know you're not going to fall for the argument that Mr. Cochran and Mr. Scheck made to you with respect to other matters in this case, that the reason they didn't do this or that is that the prosecution has the burden of proof, not the defense. If they were really governed by that fact, and it is a fact, but if they were really governed by it during this trial, why did they call 58 witnesses to the witness stand? Why did they introduce 392 exhibits? Why did they present any evidence at all? Yes, the prosecution does have the burden of proof. But I've never yet heard a defense attorney watching his client get convicted and going away to prison and saying, well, I know a lot of witnesses and a lot of evidence that clears my client, but the prosecution has the burden of proof, so I'm not going to say boo. Let him go to prison. What's much more important here is who's got the burden of proof. Surely you have to know that if the defense attorneys had any evidence at all pointing to some other person or persons being responsible for these murders, they would have presented that evidence to you. You know that. In fact, Mr. Cochran was so desperate to have you believe that someone else committed these murders that, as we've discussed, he even suggested during cross-examination, he didn't have any evidence, of course, to support this wild charge, that maybe Colombian drug lords were responsible for these murders. Can you imagine that, folks? Colombian drug lords. You know, lawyers do give wings to their imagination. When Johnny Cochran came up with this Colombian drug lord talk, I was glad that there were no windows in this courtroom, because if there had been, Johnny would have flown right out of here. As if the Colombian drug lord talk was not absurd and preposterous enough, again, as we've discussed later in the trial, he decided to come up with a new and a completely different theory. But it turned out to be just as unhinged and irrational and absurd as the first one. Maybe, he said, the killer or killers were really after Ronald Goldman because of the contents of that envelope that Ron brought with him to Bundy. But that argument is so ridiculous that no one could possibly buy that argument. For one thing, if the killer or killers were after the contents of that envelope, why didn't they take it? Not only didn't they take it, but as you folks know, that envelope, which contained Nicole's mother's eyeglasses, wasn't even opened. I have to say I'm disappointed in Johnny Cochran. He's a bright fellow, but he's been on this case for well over a year, and this is the best that he and his colleagues can come up with? Colombian drug lords? Or killers out to get the contents of an envelope that they don't take or even bother to open? I mean, these arguments are simply embarrassing. No one on the face of this earth, other than this man, committed these murders. The defense attorneys know this, so in desperation, they come up with speculations and arguments so empty and weightless in substance that they are not only floating lazily up in the atmosphere, the clouds, unconnected to any evidence in this case, but worse yet, are unconnected to any previously recognized form of logic. Both Mr. Cochran and Mr. Scheck told you folks in their summations that the prosecution didn't prove Mr. Simpson's guilt beyond a reasonable doubt. But of course we have, ladies and gentlemen. We've proved his guilt beyond a reasonable doubt 10 times over. Let's briefly look once again at this incriminating evidence. which these defense attorneys say is insufficient to prove this man's guilt beyond a reasonable doubt. And let's do it from the aspect of coincidences. With respect to all the pieces of evidence and circumstances that the prosecution has offered in this case, which point irresistibly to Mr. Simpson's guilt, do you realize, ladies and gentlemen of the jury, the tremendous, off the edge of the paper, mathematical improbability of all these things pointing towards his guilt merely being a coincidence? Obviously, as the number of pieces of evidence and circumstances pointing to guilt increases, the likelihood of any of them being a mere coincidence dramatically decreases. Just like the strands of a rope working together give the rope tremendous strength, the combination of all these pieces of evidence and circumstances working together makes the conclusion that this defendant is guilty mandatory. Let's talk about some of these, quote, coincidences. Obviously, they're not coincidences. The defense only wants us to believe that they are. The 5 blood drops at the murder scene, as well as the blood on the rear gate, all fresh blood, by the way, just happened, that is just a coincidence, just happens to be Mr. Simpson's blood. As we've said, this fact, all by itself, without any other evidence in this case, conclusively proves that this man is guilty. In fact, even if there was only one small, tiny drop of this man's blood at the murder scene, and nothing else, that would be enough to prove his guilt beyond a reasonable doubt. Because other than guilt, there's no justification for even one drop of his blood being at the murder scene. It's like the fellow comes home early from work one day. He finds his wife in a negligee. There's a man hiding in the closet. When he asks the man, "What are you doing here?" The man says, "Well, everyone's got to be somewhere." Yes, everyone does have to be somewhere. And everyone's blood has to be somewhere. But other than guilt, Mr. Simpson's blood being at the murder scene makes as much sense as that man hiding in the closet. Going on, we know from the killer's bloody shoe prints leaving the murder scene in the direction of the rear gate and alley that he wore size 12 shoes. Size 12 shoes just happens, just a coincidence, just happens to be Mr. Simpson's shoe size. From the distinctive pattern of the bloody shoe print impressions left on the terracotta walkway at Bundy, we learn that the size 12 shoes the killer wore were rare Italian-made Bruno Magli shoes. In fact, only 299 pair of those particular Bruno Magli shoes were ever imported into this country, and that was in the years 1991 and 1992. And those 299 pairs were only sold in 40 department stores in this country, one of which was Bloomingdale's department store in New York City. And as it turns out, we learned that Mr. Simpson just happens to have been a regular customer at Bloomingdale's during this same period. The glove left at the murder scene was an Eris leather light glove, which just happens to be the same identical type of glove Nicole bought for Mr. Simpson at Bloomingdale's around Christmas time, December of 1990. One of only 200 pairs like them sold throughout the country that year. And as we saw from photos and videos of Mr. Simpson broadcasting NFL games between 1991 and 1994, he just happens, it's just a coincidence, to be wearing these same identical, highly distinctive gloves. This left-hand glove found at the murder scene is a size extra large, which just happens to be, obviously it's just a coincidence, just happens to be this defendant's glove size extra large. Shortly after hearing two men arguing at the murder scene, Robert Heidstra, he's walking his dog, a defense witness, by the way, not a prosecution witness, saw a white utility vehicle, which he testified could very well have been a Ford Bronco, rapidly leaving the area where the murders occurred. Mr. Simpson, of course, just happens to own a white Ford Bronco. These murders just happen to have occurred on the same day that Nicole rejected Mr. Simpson's company at the dance recital for their daughter, Sydney. He was also unable to reach his then-girlfriend, Paula Barbieri, that day, suggesting a rejection perhaps by her also, and the likelihood that he may have been in a high state of anxiety and agitation on the day of these murders. Mr. Simpson just happens to have beaten Nicole severely in the past, to the point where she was in fear of her life at his hands, and he just happens to have threatened to kill her on previous occasions. Mr. Simpson just happens to have cut himself very badly around the very same time of these murders. We've already discussed the astronomical improbability that this type of thing would have been a mere coincidence. Also, he just happens to have cut himself on his left hand. And we know that the killer most likely cut himself on his left hand, or at least the left side of his body, because 4 out of the 5 blood drops were immediately to the left of the killer's bloody shoe prints, leaving the crime scene. Dark blue cotton fibers, the same color and material as the sweatsuit Mr. Simpson was wearing on the night of the murders, just happened, it's just a coincidence, to have been found on Ron Goldman's shirt. 9 hairs with the same microscopic characteristics as Mr. Simpson's hair just happened to have been found inside the dark knit cap found at the feet of Ron Goldman. Another of these same hairs just happens to have been found on Ron Goldman's shirt. A fiber with the same microscopic characteristics and rose beige color as those on the carpet of Mr. Simpson's Bronco just happened, just a coincidence, just happens to have turned up on the knit cap found at the crime scene. Not just Mr. Simpson's blood, but Ron's blood and Nicole's blood, the blood of the murdered victims in this case, just happens to turn up inside Mr. Simpson's Bronco within hours of these murders. Nicole's and Mr. Simpson's blood just happened to have been found on the socks of Mr. Simpson's, found on the floor of his bedroom. A bloody right-hand glove just happens to have been found on the defendant's property within hours of the murder, and it just happens to match the left-hand glove, be the mate of the left-hand glove found at the murder scene. Ron's, Nicole's, and Mr. Simpson's blood just happens to have been found on this right-hand glove. Also, hairs with the same microscopic characteristics as the hair of Nicole Brown Simpson and Ronald Goldman just happened to have been found on this glove found on Mr. Simpson's Rockingham estate. It just so happens, just a coincidence, that at the same time Cato Kalin walked outside his guest house with a flashlight to investigate the source of some thumps, some sounds he had heard against the wall of his guest house, the limo driver who saw Cato Kalin searching the premises saw Mr. Simpson coming from the same general direction of where the thumps were heard and walking briskly toward the front door of his residence. It just so happens, just a coincidence, that the right-hand glove with Ron's, Nicole's, and Mr. Simpson's blood on it was found on the dark pathway right next to the wall where Cato Kalin heard the thumps on his wall, and against which the defendant may very well have stumbled in the darkness. Of the 392 exhibits introduced at this trial by the defense. It just so happens that the heiress leather light gloves Nicole bought Mr. Simpson, the dark blue cotton sweatsuit that Cato Kalin saw him wearing less than an hour before these murders, and the little black bag on the edge of the driveway, which this defendant insisted that Cato Kalin not pick up to put in the limo about to depart for the airport, saying that he would pick it up, although he had no objection to Cato Kalin picking up the other 4 traveling bags of his. Just so happens that those 3 items were not among the 392 exhibits. In fact, the dark blue cotton sweatsuit and the little black bag, predictably, have never been seen again. Why would the defense in this case want the DA's office and the LAPD to see and chemically examine the sweatsuit and the bag? We all know, of course, what happened to the pair of gloves Nicole bought Mr. Simpson. The left-hand glove was found at the murder scene. The right-hand glove, obviously, on his Rockingham estate. What a heartbreaking thought that the gloves Nicole bought for this defendant, apparently as a Christmas present, in December of 1990, he was wearing when he stabbed her to death. Even though the temperature around 11 to 11:30 on the evening of June the 12th, 1994, between Brentwood and LAX was in the low 60s, high 50s, a cool evening. And even though the air conditioner was on in the limousine, it just so happens that Mr. Simpson was sweating and very hot in the limo, complaining 2 or 3 times to the limo driver about the heat. 2 plastic bags just happened to have been missing from the hotel room in Chicago where Mr. Simpson stayed for a few hours on the morning after the murders. Of the 24 hours of the day on June 12, 1994, the only one out of those 24 hours that the defendant, Mr. Simpson, did not have an alibi for which he could provide any substantiation just happened to be the 1 hour in which these murders occurred. Now, at what point, ladies and gentlemen of the jury, do all of these things, and there are more, stop being a coincidence? Well, of course, none of them ever were. But at least for the purposes of this trial, these things stop being a coincidence when you folks, as intelligent human beings, using your common sense, say to these defense attorneys, "Oh, come on, you've got to be kidding. It's insane to suggest that all of these things are just some unbelievable, incredible coincidence. That's not life as we know it. Stop insulting us. Show us some respect." That's when all of these things stop being a coincidence, ladies and gentlemen. When a person is innocent of a crime, chances are there's not going to be anything at all pointing towards his guilt. Chances are there won't be anything, nothing. But now and then, because of the nature of life and the unaccountability of certain things, maybe one thing, in rare situations, maybe even 2 things, may point to a person's guilt, even though he's innocent. And in highly unusual situations, very, very rare situations, maybe even 3 things will point to someone's guilt, even though they're innocent. But ladies and gentlemen of the jury, in this case, everything points to this man's guilt. Well over 50 pieces of evidence. I mean, it's so obvious that this man is guilty, he could just as well have walked around with a large sign on his back, declaring in bold letters, "I murdered Ron and Nicole." Not only does the physical scientific evidence conclusively prove his guilt, but virtually everything he said and did points irresistibly to his guilt. Under these circumstances, it's not even humanly possible for him to be innocent. I think we can put it this way. If Mr. Simpson did not commit the two murders in this case, then the two victims in this case are still alive. Winding down this final summation of mine, ladies and gentlemen, and still responding to the defense allegation that we haven't proven Mr. Simpson's guilt beyond a reasonable doubt. I mean, even if we had a film of him, you know what they would say? It's not Mr. Simpson. It's a look-alike. We must return to the blood evidence, since it remains the heart and soul of this case. As I said earlier, Mr. Simpson has told us of his guilt in his words and in his actions. But most of all, he told us of his guilt in a way that is more convincing than if he had left his business card at the murder scene. O.J. Simpson left his blood. He left his DNA. Business cards can be duplicated. DNA can't. Just like no two people have the same fingerprints, no two people on the face of this earth other than identical twins have the same DNA. In case any of you are wondering, Mr. Simpson does not have an identical twin. We learned from the testimony of experts at this trial that DNA is the genetic material found in all human cells that carries the components of our heredity, which are unique to each individual. In other words, DNA is our genetic fingerprint. However, once blood leaves the body and is in various stages of degradation because of exposure to bacteria, the elements, etc., not all other humans can be excluded as being the source of that blood. What the experts at this trial called a marker is a gene that makes up one part of the DNA molecule. And the more markers that are present in a sample of blood, the more comparison tests that can be conducted, and therefore the greater exclusion of other humans. With respect to the 5 blood drops found on the terracotta walkway at the murder scene, none of which belonged to Ron and Nicole, DNA tests showed that one of them had DNA markers which only 1 out of 5,200 people could have. Picture a vast auditorium with 5,200 people in it, and only one person in that vast auditorium of 5,200 people is likely to have DNA markers like one of the blood drops found at the Bundy murder scene. Mr. Simpson's blood has these markers. 3 other drops had DNA markers that only 1 out of 240,000 people could have. 240,000 people is a fairly decent-sized city. Yet only 1 out of the 240,000 people that live in that city would be likely to have DNA markers like 3 of the blood drops found at the Bundy murder scene. Mr. Simpson, again, has these markers. The 5th blood drop had DNA markers that only 1 out of 170 million people could have. We're talking about a huge country now. And only 1 out of the 170 million people that live in that country is likely to have DNA markers like the 5th blood drop found at the Bundy murder scene. Again, Mr. Simpson's blood has these markers. As you know, those 5 blood drops on the terracotta walkway started near the bodies of the victims and then proceeded through the rear gate out to the alley. And the richest sample of blood taken from the 3 blood stains on the rear gate, richer than the others because DNA would break down much faster on the terracotta walkway than the far less absorbent paint on the rear gate. The rear gate blood had DNA markers that only 1 out of 57 billion people could have. Mr. Simpson just happens to be that one person. In other words, just on the Bundy blood evidence alone, and excluding all the blood at Rockingham, there's only a 1 out of a 57 billion chance that this man is innocent. 57 billion people, as you probably know, is 10 times the current population of the entire world. Now, mind you, in all fairness to this defendant, we want to be fair here. I realize, I'd be the first to admit, that maybe, Igor in Moscow, Gino in Naples, Colin down Johannesburg way, Kartak up on Pluto, might have the same DNA as O.J. Simpson. And if a person were a skeptic, I wouldn't blame him at all if he checked to see if Igor, Gino, Colin, or Kartak was in Brentwood on the night of these murders, used to beat Nicole within an inch of her life, had blood all over his car, home, and driveway on the night of these murders, had no alibi, and 5 days later fled in a friend's car with a gun, a passport, and a disguise. Who knows? Who knows? Maybe this defendant isn't the murderer after all. Maybe Igor or one of the others is. The skeptic should definitely check this out. And while he's checking it out, someone should be checking him in to the nearest mental ward. A few more pages and I'll wrap this up. I know the summation has been very long, almost 3 court days. But as you know, this trial lasted over 9 months. Close to 200 witnesses. Their testimony consumed over 50,000 pages of transcript. More importantly, 2 precious human beings, Nicole Brown Simpson and Ronald Goldman, who wanted to live just as much as anyone in this courtroom, were brutally and savagely murdered on the summer night of June 12, 1994. And as the prosecutor in this case, representing the people of the state of California, I, of course, have a duty to make sure that no stone is left unturned in our quest to bring about justice in this case. In any event, after Judge Ito instructs you on the law and you deliberate, you come back with your verdict, you'll finally be able to return home to your family and your loved ones, which I'm sure you're all very anxious to do. We all know what an enormous, tremendous imposition and hardship this trial has been on all of you folks. At least we attorneys and Judge Ito could go home every night during the trial. You folks had to go back to that lonely hotel room away from your loved ones and your family and your friends. As everyday folks performing your civic duty, you've been exemplary citizens. And I want to personally thank all of you and congratulate all of you for this. The evidence at this trial that came from this witness stand under oath has proved beyond all doubt that this defendant was a human being who on the night of June 12, 1994, held a sharp knife in his right hand, the same right hand that's been holding the pen that you've seen him write notes with throughout this whole trial, and savagely plunged that knife into the defenseless bodies of 2 human beings, Ron and Nicole. In fact, 37 times, over and over and over again, until the blood of life that streamed from their bodies finally caused their hearts to stop beating. We learned from the coroner that some of the knife thrusts by this defendant were so inhumanly vicious that they went beyond mere stabbing. Some of the wounds clearly show that this defendant was actually cutting Ron and Nicole. For instance, we know that poor Nicole was almost decapitated. The horror, the fright, the terror that must have been in the eyes of Ron and Nicole as they looked into the eyes of this defendant in the very last moments of their lives is something too nightmarish, too horrendous to even contemplate for more than a couple moments. It's a type of horror that Hollywood's finest actors couldn't even begin to depict. We weren't there that night, like Ron and Nicole, to see this defendant commit these murders. No jury in any murder case ever is. But the evidence at this trial cast a very bright and penetrating spotlight on Mr. Simpson as the person who committed these murders, who murdered Ron and Nicole. Mr. Simpson, of course, has tried to run away, retreat, hide from this spotlight of guilt. But our system of law, ladies and gentlemen, is predicated on the concept of justice, which means that when you commit a terrible, terrible crime like this, you have to be punished. Ladies and gentlemen of the jury, we have beheld the form of the retreating octopus. We have brought this defendant, Mr. Simpson, back to face justice. Because of its importance, I want to reiterate to you that under the law, Judge Ito will give you, the prosecution in this case did not have the burden of proving this man's guilt beyond all doubt, just beyond a reasonable doubt. It's a much lower burden of proof. What this means is that even if one of you, for whatever reason, and I can't imagine what it could possibly be, but if one of you had some small, tiny doubt of this man's guilt, but you knew it wasn't a sound, sensible, logical doubt, that is a reasonable doubt, under the law, you would still be duty-bound to come back into this courtroom with a verdict of guilty. But the reality, of course, is that even though we had this lower burden of proof, we did, in fact, of course, prove this man's guilt beyond all doubt, beyond any doubt, or as they say in the movies or in novels and on the screen, beyond a shadow of a doubt. The evidence of guilt that we offered from this witness stand against this defendant was so overwhelming that the world's greatest skeptic, the world's greatest doubter, wouldn't have any doubt at all of this man's guilt. Based on the evidence that came from that witness stand, as sure as I'm standing here, as sure as night follows day, this man is guilty. Guilty. And this is why you folks shouldn't have any difficulty at all coming back into this courtroom with a verdict of guilty. It should be one of the very easiest decisions you've ever had to make in your entire life. Ladies and gentlemen of the jury, you are 12 reasonable men and women. That's why we chose you for this jury. The police in this case did their job in gathering the evidence. We did our job in presenting that evidence to you. Now you are the last link in the chain of justice. Nicole Brown Simpson, only 35 years old at the time of her death. Ronald Goldman, just 25 years old at the time of his death. They are not here with us now in this courtroom. But from their graves, they cry out for justice. Justice can only be served in this case by coming back into this courtroom with a verdict of guilty. You've been a wonderful jury. The plaintiff at this trial is the people of the state of California. I have all the confidence in the world that you will not let them down. Thank you so very much, ladies and gentlemen.
That's how I would have delivered my final summation to the jury had I been the prosecutor in the Simpson case. In conclusion, the judge in this case made egregiously erroneous rulings, the defense attorneys engaged in reprehensible conduct,
the jury was a disgrace, and the prosecution was incompetent beyond belief. As a result, a double murderer was freed back into society, a society whose blacks and whites were both harmed by the jury's verdict. Justice was blindsided in a 1-2 punch of bias and incompetence. Since O.J. Simpson was absolutely 100% guilty and got away with murder, I was, and still am, outraged.
In the matter of the people of the state of California versus Orenthal James Simpson, case number BA097211, on October 3, 1995, the 12-member jury of 8 black females, 1 black male, 2 white females, and 1 Hispanic male returned a verdict of not guilty. A double murderer was allowed to walk out of the courtroom a free man. The vast majority of Americans were, and still are, outraged.